May I please the Lordship, my Lord, I beg to mention item number 22, my Lord. My Lord, in this matter, I am for the Health Department. We have to file affidavit, my Lord. We have received a paragraph comment, so we need some time to file affidavit. I have taken consent from the petitioner side, my Lord.
22.
Yes,
22. As
22.
paid for by Learned Standing Council, Health Department. How much time?
2 weeks time, my Lord.
2 weeks time is granted for filing counter affidavit. List again after 2 weeks. Yes.
Your Lordship, may I pray for a date, Lordship? A date, Lordship.
Okay. Eleventh of June. List
Publish,
again
my
after
Lord.
2 weeks on 11th of June. Yes.
I will pray.
Lordship, I beg to mention item number 50, Lordship, with the concern the other side, Lordship,
50.
50, Lordship. Lordship, in this matter, I'm for the, Lordship, in IA, Lordship, the IA is led by Mr. A.V. the Lordship, he is out of station today, Lordship.
IS filed by whom?
IA
The
is filed by
petitioner.
the headmaster, Lordship.
by the petitioner or respondent?
Respondent, my Lordship.
So who's for the other side?
I am for the petition.
Any objection? How much time?
After 2 weeks, Lordship.
As paid for on behalf of the Learned Counsel for the applicant. And not objected to by the other side. Matter stands adjourned for 2 weeks. Yes.
May it pleases your Lordship.
Yes.
I beg listing of a matter on Friday, Lordship.
You mentioned before the other court.
Other bench, senior bench, I cannot because there is a notification, Lordship.
What notification?
Because I cannot appear in
Oh, I see.
the senior bench.
What matter is that?
It's a compassionate appointment, Lordship. There is a bench order also is there of this honorable court. It can be disposed of in the line of that honorable court's order.
When do you want it?
Friday,
All right.
if Lordship allows,
Yes.
deeply.
May I please, Your Lordship?
Yes.
I beg to mention item number 59 from the daily list. There is a IA, my Lord, main case already dismissed, Lordship. IA may be closed, Lordship.
What is the IA about?
IA, Lordship, we seeking a direction to not to fill up a post, my Lord. In the Jorhat MP school, Lordship.
Main case was disposed of when?
Lordship. 2 weeks ago, Lordship, probably. But I had not come on that day, Lordship. Therefore, my Lord.
Then you should be sure before making a mention. Please give item 59. Your good name?
My Lord, D. Gogoi on behalf of Mr. S. Bothakuri.
Mr. D. Gogoi, appearing on behalf of Mr. S. Bothakuri, Learned Counsel for the applicant, submits that since the main writ petition was disposed of on 8/4/2025, disposed of, you change that, was dismissed on 8/4/2025. The IA number 1327 of 2025. May be closed. Stop in view of above. The IA petition IAC number 1327/2025 stands disposed of.
Diplomist. May I please, Your Lordship? May I please,
Yes.
Your Lordship?
Yes.
Item number 8, Lordship. I am of behalf of J.C. Bora, Lordship. He is on legs on another court. In this case, Lordship, engaged counsel, Lordship, supposed to file affidavit in reply in this case. So, matter may come after 2 weeks, Lordship.
As paid for by the Learned Counsel for the petitioner. Further 2 weeks time is granted for filing a joint affidavit. List again after 2 weeks.
Obliged.
Item 8.
I got to mention item 5, Lordship.
5, yes.
May I pay for small adjournment, Your Lordship?
You are for which party?
Petitioner.
How much time?
2 weeks, maybe.
2 weeks. As paid for by the Learned Counsel for the petitioner. Matter stands adjourned for 2 weeks.
May I please, Your Lordship? With the consent of others, I beg to mention item number 35.
35.
Lordship, the conducting counsel, Mr. D. Bora has some personal difficulty. Kindly pass over this matter for the day only.
Mr. D. Bora, learned counsel for the petitioner, is said to have some personal difficulty to conduct the case today. Stop on a prayer made on his behalf. The matter stands passed over for the day. Item 35.
And for the item number 29, kindly
29.
pass over the matter for the time.
29.
Yes. I have
Yep.
taken consent from respondent number 4, 5, and 6. And AI Ali is for EC. I'm not able to communicate with
What is your good name?
P. Bhomik.
Your name is not there. Item 29.
Yes, my name is not there. In Vakalatnama is not there. I am on behalf of Bornali Bhuya, senior advocate.
As paid for on behalf of Ms. B. Bhuya, learned senior counsel for the petitioner, matter stands passed over for the day.
Obliged.
May I plead your lordship? I beg to mention for listing of a IA in review petition lordship for tomorrow lordship. Matter is very urgent lordship.
Mention it before the senior court. Court number 5. Please, yes. None appears for the petitioner when the matter is called. Stop. Same was the case when the matter was listed on 17/2/2025. Stop. In view of above, matter stands dismissed for non-prosecution. Anyone?
Item 14, Your Lordship. Item
Yes.
14.
Yes.
Next case, Your Lord.
4-0. None appears for the applicant when the matter is called. Same was the case when the matter was listed on 12/3/2025. In view of above, IA stands dismissed as for non-prosecution. Mr. U. Sharma? You are there? The contempt matter. You are appearing for respondent number 3.
Lordship may take up after some time, Lordship. Actually, in this matter, Mr. U. Sharma is there. U. Sharma, after some time, Lordship.
All right, you inform me, pastor for the time being.
Contempt.
Lordship, in this matter, I have received instruction, Lordship.
Which matter?
Item number 43, Lordship.
Yes, what is the instruction?
Lordship, there is an instruction. Lordship, perhaps a order from this court is necessary, Lordship.
What is this?
Instruction, Lordship.
Please explain the instructions. Please explain. You can't read.
These rights are there running under the central government scheme, Lordship. So
What are the direction of this court? Just see. First. Which is the order not complied with? To expedite restructuring and reorganization of diet. To expedite the process and bring the state to logical within a period of 4 months. Restructuring. 19/6 to 2023. Please file the affidavit.
Lordship,
What's your good name?
R. Dekala.
Mr. R. Dekar, learned counsel for the petitioner, for the respondent number.
Respondent, Lordship, I'm appearing for Mr. R. Mazumdar.
Okay, who's the respondent?
Or respondent, Lordship,
Appearing on behalf of Mr. R. Majumdar, counsel for the respondent. Just one respondent.
Yes.
Submits that he has received instructions. White communication dated 13/8/2024. This is not a latest instruction.
Lordship. Forty-three. Instruction is 43, contempt. I said, what is it?
Top in view of above. A week's time is granted to file the instruction by way of an affidavit. List the matter again after a week. Yes.
Publish. Madam, in this case, my lord, for status report is reported. By the department.
Where's Mr. U Sharma?
Lordship, he's on legs in court work 12. Lordship, kindly take it after some time. PK Bora will appear, Lordship, after some time, Lordship, both the cases.
That's what we said. You wait for some time.
Not against the order is defined this one. This is a contempt petition in file. Against the order, a review petition are not in file, my lord.
So, is there a stay?
My lord, review petition which is not been listed till now, my lord. Lord, say, let it come after 3 weeks, my lord. In the meantime, review petition maybe.
What is the review petition number?
My lord, review petition it has file of serial number is 2469 of 2025.
Of 2000?
25.
You have only serial number.
The serial number, my lord, this has not been listed, my lord. It has only been filed, my lord.
None appears for the petitioner when the matter is called. Mr. S. Bora, learned counsel, submits that a review petition has been filed against the order alleged to have not been complied with. Provide serial number 2469 of 2025, and therefore prays that the matter may be adjourned for 3 weeks' time. As prayed for, matter stands adjourned for 3 weeks. Okay. And the money, 2469. Serial number 2469.
My lord, in this case, we need some more time, my lord. Kindly give us 3 weeks time, my lord. Actually,
3 weeks' time.
Yes, my lord. Actually,
What was the direction?
direction was to actually, the petitioner was on maternity leave, my lord. There has been regularized. Now the case of the petitioner has been placed before the DPC, my lord, Departmental Promotional Committee, and this date has not yet been decided, my lord, for the Departmental Promotional Committee. The next DPC is yet to be held, my lord. I have spoken to the authority, my lord. They are actually they are having some talk with the authority that to consider the case of the petitioner.
Your good name, please?
As Das, my lord.
Mr. S. Das, learned counsel for the respondent.
One, my lord.
Number 1.
Yes.
Submits that the respondent authorities are in the process of complying with the court's direction and prays for 3 weeks' time to get back to the court.
Yes, ma'am.
to inform the status of the compliance. Considering the submission, matter stands adjourned for 3 weeks. List the matter again on so and so. We'll give a date. Oh, 16th of June.
हाँ चलो
Yes.
Otherwise, Lordship, we have filed our affidavit, Lordship.
What is the matter regarding?
Lordship, it is regarding release of Lordship salaries, Lordship, of the petitioners in both the cases, Lordship, 46 and 47. We have filed our affidavit, Lordship. This employee.
Affidavit filing is one thing, but main thing is
Lordship.
compliance.
Yes, Lordship. Issue is that, Lordship, here, Lordship, the petitioners were appointed under a centrally sponsored scheme, Lordship. So the fund will have to come from the central government, Lordship.
Which order has been not complied with?
If order at
3524. Is it?
Lordship, order at page 34, it starts from 35, Lordship.
This petition stands disposed with a direction to all respondents to take all steps necessary for release of the arrear monthly salary payable to the petitioner.
Yes, Lordship, the
If
direction.
sufficient fund is not available, necessary proposals will be made by the respondent number 3. Entire exercise be carried out within 90 days. This was passed in 3/5/2024.
Yes, Lordship. Thereafter, we have submitted repeatedly, Lordship, before the central government, Lordship, for release of fund, Lordship, and everything has been annexed here with, Lordship.
Where?
Lordship, in my
What affidavit have you filed? Affidavit in reply?
affidavit in opposition, Lordship.
Opposition.
Yes, Lordship. At page 42, Lordship, may see, Lordship.
Where is your affidavit in opposition? Filed by whom?
Lordship, by the sole respondent, Lordship. Contempt.
Dr. Achyut Chandra Vaishya.
Yes, Lordship.
Which paragraph?
Lordship, page 42, Lordship.
42.
Lordship, may I read, Lordship?
Yes.
It is also relevant to mention here in that looking at the hardship of
From
the
where are you reading?
Lordship, page 42, second para, Lordship, the third line.
Second para.
Yes, the third line, Lordship. Page 42.
Paragraph number.
Paragraph. It is 4, Lordship.
Paragraph number 4.
It starts from page 40, Lordship.
No, you want page 42.
Yes, Lordship.
So in page 42, it starts from paragraph number 3.
Lordship, it is also relevant to mention here in that, Lordship.
Why did you read from the middle? Read from the beginning.
Yes, Lordship. Para 4, Lordship.
Yes.
May I read, Lordship? Lordship, as regards to the statement made in paragraph number 7 to 13 of the contempt.
7.
Lordship, para 4, page 40 of my affidavit in opposition. There might be
Something wrong with the petition. Affidavit is filed by Dr. Achyut Chandra Vaishya.
Lordship, yes, Lordship.
Okay, then there are paragraph. Your affidavit is not numbered.
It has been numbered,
You
Lordship.
tell me the number.
Lordship, my affidavit starts from page 38.
No, don't forget the page. Tell me the paragraph number.
4.
Paragraph number 4 starts like this. That as regards the statements made in paragraph number 4. Correct?
Lordship, it is the affidavit in reply filed by the petitioner, Lordship.
You are talking about affidavit in opposition. What are you reading?
Lordship, 1 second, Lordship. There are 2 cases, Lordship. Lordship, I'm sorry, Lordship. It is 487, Lordship. So it starts from page 42, para 6, Lordship.
Yes.
That as regards to the statement made in paragraph number 7 to 13 of the contempt petition, the deponent begs to state that as per Government of India Ministry of Health and Family Welfare Department, Nirman Bhavan, New Delhi, later dated so and so at point 5, which states that support of HR under the Trinity Care programs will be limited for the period up to 31st March 2024. Beyond that period, the state would have to deploy their own resources for meeting their operational expenses, including for HR for all the facilities that are being created in the Trinity Care programs. It is pertinent to mention herein that the Government of India have not released fund for the financial year 2023 and 24 until that no fund in this regard has been received from the Government of India. Due to non-receipt of fund from the Government of India Ministry of Health and Family Welfare Department, the salaries has not been disbursed to any of the staffs of Regional Geriatric Center, Guwahati Medical College and Hospital since April 2023. Accordingly, communication was made to the Government of India Ministry of Health and Family Welfare Department by letters mentioned below. Lordship, these are all the letters that we have communicated to the ministry for release of fund, Lordship.
This was before disposal of the writ petition.
After the disposal of the writ petition.
What are you saying? When was the writ petition disposed of?
Lordship, they have asked us to,
Mr. Counsel,
Yes.
don't confuse the court.
Lordship, the,
Writ petition was disposed of on 3/5/2024.
yes, Lordship. And
Correct?
Yes, Lordship.
Then you are referring to a communication of 2023.
Lordship, this was from the central government to the state government. and-
Maybe.
Yes,
You have been directed to take certain steps
yes, Lordship.
for payment of the salaries.
Yes, Lordship.
If the fund is not available, you must write.
Yes, Lordship.
You are showing me some communication of 2023.
Lordship, the communications are serially there, Lordship. At 3, Lordship, it is 10/5/2024 after, Lordship, the disposal of the writ petition.
Where?
Then, Lordship, 18/6 at serial number 4, sent by the nodal officer, Lordship.
Where are you referring to?
At page 44, Lordship. The third communication, Lordship. It is dated 10/5/2024. After disposal of the writ petition. Then serial number 4 is an email dated 18/6/2024. Then again on 30/10/2024. Lordship, we have been repeatedly asking them for release of the fund, Lordship.
Then what is the response?
Response, Lordship, we are still awaited. The fund is yet not released, Lordship. The fund is.
Whom have you written to?
Yes, Lordship, the central government, Lordship.
Where are the letters?
Lordship, in this, Lordship contempt petition, this has not been annexed, Lordship, but in the other contempt petition, that is Lordship 482/24, that is the next contempt. Lordship, there I have annexed all the letters, Lordship.
Let us see.
It starts from, the communication starts from page 46, Lordship. Lordship, to the Ministry of Health and Family Welfare, to the central government, Lordship.
You show me the communication which was written after the disposal of the writ petition.
Yes, Lordship. Lordship, at page 53, Lordship, this was an email, Lordship,
53.
dated 10/5/2024.
Where is the mention about the court's direction? This is on your own, you've written.
Lordship, then in that case, Lordship, I'll get the details, Lordship, whether they have communicated about the court's direction. Otherwise, Lordship, these are all employed by the central government, Lordship. So, Lordship, I'll get the communication, Lordship, if they have
Please
communicated.
write, none appears for the petitioner when the matter is called. Stop. Although Mr. D. Upamanil, learned counsel, appearing for respondent number,
Lordship, sole contempt in both the cases. Sole contempt.
appearing for the sole respondent in both the contempt petitions, submits that steps have been taken for compliance of the court's direction. But the documents annexed to the affidavit filed by the respondent does not disclose that the fund was sought in terms of the direction passed by this court. To stop, the learned counsel submits that he may be given some time to obtain instructions in the matter. As prayed for, 2 weeks' time is granted. List again after 2 weeks.
Highly obliged.
May I please? My lord, kindly see the order set my lord 21/4/2025. Learned defending counsel PNRD was my lord directed to the substitution.
Yes.
Lordship, the instruction is awaited.
Hmm?
Instruction is awaited, Lordship, so more time will be given.
You are appearing for which?
As to the Lordship, for PNRD department. Our name has not been reflected in the cause list. In last occasion, they have
This is item 48.
lodged
D. Saike is there, RB Bora is there, S. Bora is there.
as the
S. Datta appears for whom?
in our commissioner.
Yes, file is Vakalatnama.
Lordship?
Has he filed his Vakalatnama?
No.
Why?
On last
This is a
occasion-
contempt petition.
Last occasion.
My lord, on the last
Do
occasion.
you appear without Vakalatnama?
No, my lord.
Standing counsel will appear in contempt.
My lord, on the
On-
last occasion, my lord, the honorable court was
That-
directed
that
to,
is-
my lord, the S. Dutta, my lord, learned standing council of PNRD to obtain instruction from the commissioner and secretary PNRD department, my lord, as to why my representative has not been, my lord, disposed of, my lord. That is why, my lord,
So-
their time has not been.
You want some more time?
Lordship.
How much time?
2 weeks.
On a prayer made on behalf of Mr. S. Datta.
My lord, shortcut may be given, my lord, since it is a contempt petition, my lord. It is pending law. My lord, earlier, my lord, my lord, kindly see, my lord, page 20, my lord, kindly see, my lord. From bottom to above paragraph, my lord, Mr. P. Hendik, learned counsel has pointed out that the commissioner PNRD is not an appropriate authority to consider the grievance of the petitioner. He submits that the appropriate authority is Principal Secretary BTC as the petitioner retired from Gosaigaon Mahokama Parishad in the district of Kokazar. My lord, in terms of this submission, my lord, honorable court, my lord, disposed of my case, my lord, that is last paragraph, my lord. Considering the above, the writ petition is disposed of by granting liberty to the petitioner to file application before the appropriate authority, that is the Principal Secretary BTC Kokazar. In the event of the petitioner files an application, it is provided that the respondent authority, that is the Principal Secretary BTC Kokazar, shall consider and dispose of the application within a period of 2 months from the date of receipt of the application, my lord.
So application has not been disposed of.
No, my lord, still not disposed of, my lord. Subsequently, my lord, BTC authority, my lord, again, my lord, submitted before this honorable court on the last occasion, my lord, with written instruction, my lord, that BTC authority is not appropriate authority to my lord, to settle my grievance, my lord. That is, my lord.
Okay, cancel the order. Please write. In terms of the last court's order dated 21/4/2025, Mr. S. Datta, learned standing counsel, PNRD department, was required to obtain instructions in the matter. Stop today when the matter is listed. Further 2 weeks' time is being sought for on his behalf to get the instructions. Stop considering the submission made. Let the matter be listed again on 9/6/2025. Showing the name of Mr. S. Datta in the cost list. Stop, Mr. Datta shall obtain instructions by them.
Published.
Your name? Miss S. Boro, learned counsel, appears on behalf of Mr. Miss R.B. Arbora. On behalf of Miss R.B. Bora, learned counsel, appearing for respondent number 1. Okay.
Published.
Public.
Actually, the petitioner herein preferred a petition before this honorable court, praying for family pension, which was granted in favor of private respondent number 6. The petitioner is the first wife, private respondent number 6 is the second wife, but it is an admission. Thereafter, during the pendency, matter was settled between the parties. 50-50, because the petitioner, respondent number 6 had a minor child. So 50-50. However, in spite of that admissions agreement, she failed to pay that amount, 50%. That petitioner went to the AG office. AG office says we cannot grant it unless otherwise it is directed by the honorable court. Therefore, my submission before this honorable court, as the petitioner respondent number 6, private respondent number 6 has failed to pay the amount. Therefore, it becomes necessary. So by that, I submit before this honorable court to direct the respondent number 3, AG office, to grant the pension 50 in the 50-50 basis.
Okay, what is this IA for?
IA was for that as she failed it. IA was for compromise petition. It was IA was filed between the parties as the compromise petitions.
IA is filed by whom?
Petitioner. Jointly it was filed.
Jointly it was filed.
Lordship.
So who is appearing for respondent number 6?
On the last occasion also there was no. She has avoided. There was a letter, registered letter written to her respondent number 6. She did not reply also. Therefore, her intention is very clear that she is not going to pay. And the payment last 2 years passed. Petitioner is yet to get the 50% pension. As regards to the arrears payment, since the order of passing of the order, that we may have to prepare a civil suit because that will be a money suit. But as regards to the present pensions, I submit before the Honorable Court to direct the respondent number 3 to divide the pension between the petitioner and the respondent number 6.
So where is that compromise agreement?
At page 20, Annexure X.
20.
Very simple one. The clause number 2, that the second party is not entitled to receive the family pension. However, her minor son, being the legal heir of Prasanna Kumar Das, is entitled to receive half share of the family pension along with the petitioner. First party petitioner. This simple.
The IA that was disposed of by the Honorable Court Lordship Policy, page 25.
Lordship.
25, that is they filed a IA, they have compromised outside the court, that's why court, they did not press the matter, they disposed of. There is no direction from this Honorable Court on the compromise petition, my lord, to pay to whom. That's why the matter relates to my lord, respondent number 6 and the petitioner, and the court has nothing to do. That's why my lord, pension department has said what we can do, because they have compromised outside the court. So they can go to the civil court. Because
No, that will be
she is claiming as a first wife, but in the official record, the respondent number 6 name is there for pension. These are the record. So the outside the court, so the lordship, how lordship will direct them, mother? Because this is in between the 6 and respondent 5. Let them go to the civil courts for declaration. Otherwise, my lord, the lordship cannot direct it.
Yes,
Because
repetition may be called.
that petition was disposed of, lordship page 25. There is nothing, my lord, only because of the compromise so and so. Petition is then dismissed as not placed. Parties have amicably settled the dispute.
Correct. So how hope of
Lordship,
passing any
lordship,
order?
the problem is that let the writ petition also come. In the writ petition, there is a affidavit. In the affidavit, respondent number 6 categorically stated, yes, I'm the second wife. It was my marriage was with the second part. First, what is that? By way of compromise, by way of agreement. So agreement marriage is not valid. Both the parties are Hindus. So therefore, because the Honorable Court directed dispose the matter on the basis of because agreement, there was a compromise agreement between the parties. And that-
Correct. It's a compromise agreement between the parties. Court has nothing to do with it.
Yes.
Lordship, the problem
You had
will-
come before the court. In the meantime, you had entered into a compromise agreement with the respondent, private respondent. So court said, okay, fine, in view of the compromise, disposed of.
in that case,
Now you are pressing by an IA saying that you compel this respondent number 6 to pay. How can we direct that?
Lordship, in that case, that statements given, agreement made before this Honorable Court by the respondent number 6 carries no meaning.
No meaning, what to do?
That will be difficult for the petitioner. My submission before this case.
See,
Meanwhile,
see.
we'll file appropriate petition, appropriate application before the respondent number 3 AG office, so that they may consider that one. The respondent number 3 has said, no, we have no nothing to do. My submission in civil process again will take.
You file if you want to.
In that case,
We are not, court doesn't have to advise you what to do. You do what you have to do.
Yeah.
Yes, 6,
That field, AG,
okay.
that question, that respondent number 3, I may be allowed to submit this representation before the respondent. That is already answered. Yes, annexed it in the petition. It is already answered in the petition. The lordship will kindly go to page 29.
So what is answered?
that we have already settled the pension.
Ah.
That's what the pension case was. Respondent 6 was named as the.
Yes, this is.
Then, yeah, the next thing.
No, correct. See, respondent number 6 name is there in the pension papers. So accordingly, respondent number 6 is given. But when we filed the writ petition here, they came to an agreement. Okay, we'll share 50-50. Correct.
In between them, my lord.
So when she said 50-50, then they say that I'll not press the writ petition. Writ petition disposed of.
Yes.
Agreement copy also was given to the court.
Yes.
And court says that in view of the agreement, not press disposed of.
Now, better.
Now what can we do?
Yes, civil court, my lord. On go to civil court, they can go. So specific
Lordship,
purpose.
my.
No, no.
There's no scope.
My.
For specific
This
purpose.
court has not adjudicated the case, saying that now you must comply this order. We have not passed any direction like that. So
Well,
how can you,
That is
how
why I
can
have
you-
filed this. This is why I filed this IA petition.
how can you ask the court to enforce, the High Court to enforce the agreement which you reached between the private respondent number 6?
Order passed by in writ petition may be modified to that extent.
How can we do?
How can you modify that?
Because I have filed a separate IA petition at this stage. My prayer is specific. My prayer is specific is that if the respondent number 6 does not honor the commitment before this honorable court, then respondent number 3 may be directed to take arrangement for grant of 50% pension. And there is a so is it called judgment of this honorable court also. Full court.
Petitioner has to now obtain declaration from the civil court, then define things. But
You withdraw or I'll dismiss it.
My problem in that case,
I can't do
civil
anything.
court again, it will take many
It
years.
may take time, but that doesn't mean that because it'll take time, you can come and file an IA
When that.
and compel the court to
When the
pass
matter
such
is
kind of
admitted.
order. Not possible.
Lordship, when the matter is admitted, what is admitted by the respondent number 6, she is the second wife. By of agreement, marriage. So that she is not entitled to get family pension. Even of her name, it was actually willfully, it was done by the husband. So to put her name in the service records, just because the service records, it was misled that.
Mister, you take recourse to other procedure, not this. There's no point in keeping this
civil
pending.
court with declaration. Specific purpose.
Only thing that poor lady will suffer again somebody else.
What to do?
Actually.
What to do? We
when
cannot
it
have
is
any shortcut
admitted,
like that.
The commitment has been given.
Law does
for
not
a-
permit to pass such
Lordship,
kind of
the
order. So
commitment is-
you don't ask something which is not permissible. You withdraw, I'm going to dismiss.
Liberty, I shall highly approve.
As paid for by the learned counsel for the applicant, the application stands dismissed as withdrawn. With liberty to
Highly
appropriate
appropriate application before the competent
Appropriate
forum, as may be
appropriate
permissible in law.
Yes, yes. Obligation.
This may be recorded.
I am for respondent number, my lord, 4, 5.
Mr.
Lordship,
B.K. Bhagavati,
Bhagavati.
learned counsel appears for the applicant.
I am for
Mr.
4, 5 and
D.
7.
D. Shutia,
TCT.
D. Shutia, learned additional senior government advocate, appears for respondent numbers
4, 5 and 7.
4, 5 and 7, and Mr. D. Bhattacharya appears for AGSR.
Obligation.
In this case, we are constituted a committee to verify all the data, all the status of the teachers.
You are
I am for secretary, and for respondent number 1.
You are Mr. U. Sharma,
PK Bora.
B.K. Bora.
I need some time, in similar cases, they're listed in the different courts, because we are processing the. We have initiated the process to compliance the order, that is why we need some time, Committee has constituted to verify all the datas who are eligible,
How much time?
3 weeks time will be granted,
Mr. P.K. Bora,
Malak,
learned counsel appearing for respondent number
1,
1.
Malak.
Submits that the respondents are in the process of compliance of the court's direction. And he may be granted 3 weeks' time to come back with the up-to-date status.
A date may be given after.
Considering the submissions made, that the matter be listed again on 16th of June,
1 and 3, both lawsuits, respondent 1 and 3.
1 and 3. Okay.
But another connected contempt case is there, my lord. It may come along with that.
16th of June. along with contempt case C number
Contempt case C number, my lord, 595/2024.
595
5.
of 2024. Have you got it?
Obliged, Lordship.
Obliged.
Then one more line, Mr. B. Prakasta, learned counsel appears for the petitioners. Okay.
Obliged.
My lord. Sorry, my lord, item of 44, my lord. The signing was very urgent matter, my lord, it's a contempt matter. Little bit stuck because of the rain, my lord. 44.
44, what is the order passed?
This after, very urgent matter, my lord, because a contempt matter, my lord.
Item 44.
Oh.
What's your voice there?
The two order has not been complied with, my lord. There is two order of this.
Item 44. Come on. Yes, what is the urgency?
And the contempt matter, my lord, because there are two order of this court.
You're for the petitioner.
Yes, yes. I'm petitioner, the petitioner, my lord.
We have adjourned it for 3 weeks.
Like 2 weeks, my lord, because the 4 men, my lord, he's working since, my lord, 86. Service has not been regular. Even in spite of your lordship order, my lord, two order of this court, my lord, that service has not been regular.
And share letter. Hmm. Hmm. So tell me which order has not been complied with?
No, not been complied with, my lord.
Hmm.
They have not been complied with, my lord.
Which order?
The first order, lordship kindly say it, page 16, my lord.
Page 16.
Yes, ma'am.
What was the direction?
To regulate, sir. Second, internal paragraph A. Be that as it may, since the petitioner has been working since 86, post held by the petitioner was retained permanently with effect on so and so, also normalized vice government number so and so, as mentioned in paragraph 7 of the opposition filed by the respondent 4. This court is of the view that there should not be any difficulty on the part of the authority grant regular pay to the state grade 4 post or sweeper held by the petitioner since 1983, which has been permanently retained. Accordingly, authority will pass appropriate order for grant of regular pay attach the post of grade 4 sweeper to the petitioner, which exercise shall be undertaken within a period of 4 months from the date of the receipt of the certificate of the order. That is order in 2019, my lord. They have to what happened, my lord? Only I they've giving us, my lord, only, my lord, permanent scale, my lord. Service has not been regularized, their permanent scale has been given. They have another petition has been filed, and that order received fine at page 17, relevant page 19. Page 19, my lord. Second but last paragraph. It appears that the direction of the court dated 6/9/2000 has been complied with. Therefore, there is no necessary passing any phase order of the same. With the approach of present petition sent close with direction to consider a pair of the petitioner. 86, my lord, service. I've been working, my lord, as service has not been regularized, my lord. They after this, I will call.
So
After this order, I will call to the my lord, office, my lord.
the secondary petition,
Yes, my lord.
court passed the order saying that the order has been complied with, so it has been closed.
Permanent, second paragraph, last paragraph. With the direction to consider a pair of the petitioner. Last line, with a direction to consider a pair of the petitioner. Pair is equal to regular service of the petitioner. So Lordship, from 2024, my lord, asked the my lord, contempt to file my lord affidavit in opposition, they have not been filed, my lord.
What is the prayer of the petitioner?
Prayer, my lord, to regularize the service of the petitioner, regularize, my lord. Not for permanent skill, my lord. As for first, I am giving the regular skill, permanent skill, my lord.
So what is the process then?
And they will, and after this order, my lord, they call me to submit a regular paper. Paper, my lord, I have submitted, my lord, what we find it, my lord. Last page, my lord, page 23, my lord. They ask for hearing, my lord, for regulation. Kindly turn to page 23. That there's a letter given by the director SCRT, my lord. Kindly see, with reference above, I am the informed with the hearing regarding the regulation of service, nature, appointment, pay, creation of permanent and nomination of the post of sweeper, being held by CSR Saturday bus for is going to be held on 15/7/2023 in the office chamber of underside. You are therefore requested to present the hearing on that day and time positively with all original documents, file a record of the matter able with you. I am appear, my lord, but service has not been regulated.
So after that, what happened?
They have called for hearing. I have submitted necessary document, but until now, my service has not been regulated.
So who appeared for the, Mr. Bora was there?
Bora was appearing on,
Hmm.
because he is on late in corner 14, I had just
Mhm.
enquired Lordship.
Oh,
So Lordship is, can we take it off sometime? Let Bora come. Lordship.
okay, you canceled the order last time. This will be passed over for the time being, okay?
Yes.
Let him come, we'll
Yes.
see.
Right, with your lordship. Office note dated 9/4/2025, service has been completed upon respondent number 5 to respondent number 9.
Okay. These are private respondents. Or what?
Yes, yes, lordship.
Anyone appearing for 5 to 9? No one.
I am preparing for 2, 3, 4.
Yes, what is the submission?
Lordship, we have received instruction that the petitioner does not submit some important documents like voter ID and death certificate of private respondent 5 to 9.
What is this regarding?
And for both the parties are called for hearing, but petitioner does not come. And parawise comment also received that.
You file the affidavit.
Yes.
Lavazima Court's order dated 9/4/2025 indicates that service upon respondent numbers 5, 6, 7, 8, and 9 is completed. From the postal tract consignment reports. Full stop. In view of above, notice is accepted to be completed upon the said respondents. Miss
S. Borua,
S. Borua, learned counsel appearing for respondent numbers
2, 3, and 4.
2, 3, and 4, submits that she has received the paragraphs comments and prays for 2 weeks' time
Yes, that's
to file the counter affidavit. Prayers allowed. Just again after 2 weeks.
obliged.
So Bora,
And the review had not,
Mr. Boro. Mr. Bora, what has happened here?
my lord, against that order, review petition already been filed, my lord. I have already informed lordship at the particular CL number also, my lord. That will
Okay,
be-
okay, that review case.
That review. My lord, what had happened, my lord?
No, I had given some dictation here, but what was read to me, I could not understand.
My lord,
So
since the contempt petition is filed against the order, particular order, my lord,
serial number 2469.
2469 already been filed, my lord. Against
Why,
the-
why did you file review petition?
Because in the review petition, my lord, suddenly there is no contention from the petitioner nor even from the
Review of which order?
review order dated.
The first one or the second one?
6/9/2019, my lord.
Huh?
6/9/2019. This is the first order. Passed by Honorable Justice
No, just a
and
minute.
quotation. Lordship will find in page number 14 of the review of the contempt petition.
6/9/2019, you filed
6/9.
review.
Review petition has been filed. Issue has not been. This person has came into the job, my lord. Since the father of the petitioner has left the job, he was allowed to continue. When the issue had come up that his appointment is a compassionate appointment. The moment it's a compassionate appointment, entire scenarios is a different one, my lord. We have to get all this from the here to appointment, regular post, and all these things have come. All this come. And so that issue has cropped up, my lord. This is not a compassionate appointment. It is he was only allowed to join, and this person has petitioner has continued. Nothing, no advertisement, nothing. He is only allowed to join because his father was working there. He left the job. He said the official that my son will continue, and that cannot be a compassionate appointment. My lord. And Lordship will find in paragraph number 5, my lord. It has clearly stated this is a compassionate appointment. That portion has to be corrected. My lord. Otherwise, there is no difficulty in getting all
The matter was disposed of
disposal.
on the ground that it was a compassionate appointment.
It was not a compassionate appointment.
And you're saying that it is not a
Not
compassionate
compassionate.
appointment.
That's the issue, man. That record has to be corrected. Man. And even my friend agrees that is not a compassionate appointment.
No, then why didn't you take that stand at the relevant time?
The relevant it was not, the file was processed. It was, thing is that even the authority that at that point believed that this order was examined, my lord. Ultimately, we found out that it is not a compassionate appointment. To implement the order when everything has been scrutinized, my lord, then the issue came up. It is not a
See,
compassionate
is it not too late in a day?
appointment.
The order was passed.
Yes.
Saying that since it's a compassionate appointment, you should take necessary steps in giving regular pay.
Regular pay,
So you have given regular pay.
he's getting it. There is no
Now he
difficulty.
says that, no, I want a regular appointment
that
apart from regular pay.
regular pay is also,
So that issue still remains.
yes, the compassionate
And
appointment.
today you say that, no, actually what happened in the earlier date, when the first writ petition was disposed of, we were not aware about the fact that it is not a compassionate appointment. Now that we know that it's a compassionate, not a compassionate appointment, we will file review.
The review petition has been filed, my lord.
So we don't know how long that review will take
Lord,
because
That he is getting his regular salary. That is not, he is getting it, my lord. Only lordship will, because unless this compassionate appointment, then that the compassionate appointment is defined under a scheme. It will be totally different thing, my lord.
The only thing, whether this issue can be raised in this one forum, because he said that, I am not appointed on compassionate.
No, that's why review will be filed.
Because at the Umadevi case, this point has been raised, in Umadevi case, if a person is working for more than 10 years without intervention of God, in that case, his service will be regularized. Whether a compassionate appointment, contractual, that's different thing. And I have been working more than 10 years, before the passing of the judgment, one be that.
All right. See, we are not concerned with all the entire story. You see, we are only concerned with the orders not being complied or not. That's all. This is a contempt petition. So we're not conducting any rehearing of the writ petition. So what we'll do is we'll record his submission that some review has been filed. We'll adjourn the matter for some time. That is what we can do at the same time. Your good name, please. Mr. R. Barwa, learned counsel appears for the petitioner, and Mr. S. Bora, learned counsel appears for respondent number 3. At the outset, Mr. S. Bora, learned counsel submits that a review petition has been filed against the order dated 6/9/2019, passed in WPC number 7018 of 2016. White serial number 2469 of 2025. Stop. He submits that pending consideration of the review petition, he prays that the instant contempt petition may be kept in abeyance. Stop. On the other hand, the learned counsel for the petitioner, Mr. R. Barwa, submits that the petitioner had filed 2 writ petitions, and as per the order dated 16/12/2022, passed in WPC number 3812 of 2020, the respondents were required to consider the case of the petitioner for regular appointment. Stop. The process was already initiated by calling him for hearing. White communication dated 5/7/2023. But
15.
Hmm?
15, 1 5, not 5, 1 5.
Page 23.
Yes.
Where is 1/5? This is 5/7/2023.
1 5. 1 5.
Hmm?
1 5. 15, not 5. Last line. Last line of first breakup. On 15/7/2023 at 1 PM in the office of the chamber of the undersigned.
That's okay. I'm referring to the communication date,
Yes.
not the date of your interview.
Yes.
White communication dated 5/7/2023, correct?
Yes, sorry.
Asking him to appear on 15/7/2023. Stop. Since the process has already been initiated, the respondent should be directed to complete the process. Stop. Next para. Be that as it may, since Mr. S. Bora, learned counsel, has submitted that a review petition has been filed, this court deems it appropriate to adjourn the matter for 3 weeks. List the matter again on so and so. We give a date. Oh, 16th of June. You do something, Mr. Bora. If nothing happens, then we'll have to go ahead.
My lord, I'm sorry, my lord, I was under the impression that matters should be started from admission management. My lord. I am, my lord, appearing in 46 and 47, my lord.
They have passed order
Yes,
already.
my lord. So may I pray for a date, my lord?
It's not dismissed.
Yes, sir. May I pray for a date?
What date? We don't know what order has been passed. It's already passed, but it's not dismissed.
Yes, my lord.
You make a mention later on.
Yes. Diplo.
Yes, 52.
Page 10 against the order dated 67/24, my lord, whereby my appointment at Gauguda was cancelled without affording any opportunity to the petitioner, my lord. Page 10 is the order.
Lordship, today we have filed our affidavit. Lordship, let the affidavit come on record.
No, my lord, I have not received not last 2 occasions that took time, my lord, to file affidavit.
Lordship,
Give him an affidavit
I will give it.
just now.
Lordship, just now, I don't have the copy. My clerk have the copy.
I mean, how
Why?
it can be filed, my lord, until and unless it is served me upon me, my lord. Registry will not accept, my lord.
That's what.
Lordship, today I will provide the copy of the affidavit.
So how do
Then
you
it-
file, how do you file affidavit without giving copy?
Lordship,
By
I
way of
gave him the
undertaking?
copy to the clerk. He is filing the affidavit.
Filing, my lord.
So let them file.
Let it be on Friday, my lord,
Yes, your lordship.
on Friday.
Yes, your lordship.
Your good name?
D Jane,
Sorry,
D Jane. Diksha Jane.
Jane.
Yes, your lordship.
Ms. D. Jane, learned counsel for the respondent.
1 and 2.
Numbers 1 and 2 submits that counter affidavit is being filed during the course of the day. In view of above, list the matter again on Friday.
Obliged.
Obliged.
Please give the date.
My lord, after amendment of the petition, my lord, by correction of designation and proper addressment, respondent number 9 and respondent 13 may we issue notice, my lord, afresh. And in respect of other respondent, my lord, my learned then we submit affidavit in opposition.
So affidavit is ready, lordship, send it for vetting. And also instruction received, then affidavit sent, it is for vetting, lordship.
When can you file?
Lordship, after receiving the vetted affidavit, lordship, then we'll file it,
You have sent it for vetting.
lordship.
How much time?
2 weeks, lordship.
B. Chaudhary, isn't it?
2 weeks.
You're
From
you're Mr.
A Chakravarti.
A. Chakraborty, sorry. Appearing for all the respondents.
No, lordship.
One,
Lordship,
I'm appealing for one,
One.
three.
one,
Is it appealing for
3, 4, 5, 6, 3 to 8, lordship, 3 to 8.
But the
4 to 8.
last court's order records that you are appearing for 1 to 8.
Lordship, it's by mistake, lordship.
What about you? You'll be filing?
Receive instruction, lordship, we can file within 2 weeks, lordship.
All right. We'll give them 2 weeks' time,
Lord.
as paid for by the learned counsels appearing for the respondents. Further 2 weeks' time is granted for filing counter affidavit.
But in this case,
my lord,
our non,
fresh notice to be sent to respondent number 9 and 13.
Why?
Because my lord, address was wrong, my lord. So we modify the address and proper designation of the incumbent.
So what do you want to do?
And a fresh notice to 9 and 13, my lord. Where?
Have you got the address?
Yes, my lord, I've corrected the title.
Petitioner to take fresh steps up for service of notice upon respondent numbers 9 and 13
13, my lord.
within 3 working days.
if our name is not reflected in the cause list, lordship, registration will be directed to list
Name of
SC revenue.
SC revenue be also reflected in the cost list hereafter.
Obliged.
All right.
Lord, I take your lordship to
My
the
lord, here I need some time. This content was listed only on the last 14th of May, lordship. That they have submitted that the petitioner has already given that GIS and leave encashment benefit. So for further instruction, lordship, I need some time. So he has petitioner has filed another writ petition. So it has come along with that writ petition, lordship. So in the writ petition also I need some instruction.
Lord, let me just clarify one thing. This honorable court has in the order, my lord, the page number 20 has already settled the issue.
20 of what?
20 of the contempt case.
Contempt.
Contempt case, my lord.
Yes.
This is the order passed in the review petition, my lord, by this honorable court, whereby the service of the petitioner has been declared to be provincialized with effect from 1/1/2013 till the date of his retirement, death, till he expired on, my lord, 31/1/2022. Original petitioner expired. Thereafter, the wife of the petitioner has been substituted. This is a mandamus, my lord, issued by this honorable court. After this mandamus, my lord, what they have done in the name of compliance of the contempt case, they have conducted a hearing. Whereas this honorable court has conducted hearing and passed the order. They have conducted, the director secondary education has conducted a hearing. And in the hearing, My lord, there is no requirement of hearing, only to pass the order, compliance order with regard to the provincialization of the husband, late husband of the petitioner till his date of death with effect from 1/1/2013. Instead of doing this, my lord, they are derailing the process, my lord. As a result, what happened, the inspector of schools concerned, my lord, respondent number 3 in the writ petition, they have been pressurizing the petitioner to fill up the form of gratuity, showing that, my lord, he has expired after the retirement, after the retirement, my lord. That is causing a problem. And family pension has not been processed till date, my lord. The second writ petition is for the pension entitlement, my lord. For the claim of pension, compassionate family pension, to which the wife of the petitioner is entitled to. Or petitioner means, my lord, wife of the late husband, my lord.
All right, so let Mr. Chisti obtain instructions.
Yes, proceed.
Since it was clubbed together,
Both the things therefore
so
clubbed together.
it came earlier than expected.
Yes.
Earlier
Isn't
than
it?
expected, but in the meantime, my lord,
Because writ petition itself was fixed for today.
yes,
Contempt was not fixed for
not fixed
today.
for today, but
But since
as
it was clubbed together,
clubbed
it has come along.
that's why it has come today.
So.
So
let me
both
take-
item till after 2 weeks, let's say.
A date may be given, my lord, in that event.
Mr. SMT Chisti, learned counsel for the respondent.
Yes.
Seeks for further 2 weeks' time to obtain instructions of the matter. Praise the Lord. This the matter again on. I think we'll have it on 11th.
Yes, yes. Obliged.
I'm the senior most assistant professor, my lord, of Sontoli Ansolik College, my lord. But here what has happened, my lord, the second nominee has given the in charge post of the principal of the said college, my lord. Here, my lord, I have submitted representation.
Second nominee,
Second nominee, he is the second senior most assistant.
second senior most has been given.
Yes, my lord.
So what is this IA for?
I is, my lord, during dependency, I have challenged the order of the in charge order of the respondent, private respondent regarding that in charge post of the particular, my lord, college, my lord. During dependency of the case, this I have filed because, my lord, it is extended, my lord. But here, annexure 1 in the IA, my lord, in continuation of the.
Anyway, let us be more concerned with the notice. This is listed for orders.
Yes, my lord.
Today.
Let it come for admission hearing, my lord,
Ah.
on 29, my lord.
So
Other service complete, my lord.
this is as per the Lavazima court's order, is it?
Service
3, 4, and 5.
5 to 5, 25. There is a office note.
Yes, the notice on 3, 4, and 5 respondents, isn't it?
Yes, my lord. IA also it is.
Who is appearing for the department?
1 and 2, Lordship.
1 and 2.
There are criminal case also against.
We
the-
have to file affidavit 3 weeks time in granted, Lordship.
How much time?
3 weeks time, Lordship.
On the IA?
No. I have to recover again. Main case to.
You're not aware about the IA?
Lordship, we will file, we will file in main case, Lordship, and dispose the whole matter, Lordship, in the meantime. Lordship, fix the matter in admission, Lordship. In the meantime, we have filed the affidavit and dispose.
Please write, okay, please write, please, Mr. H. Das, learned counsel, appears for the applicant stroke petitioner, while Mr.
As Bhuya,
S. Bhuya, learned counsel,
higher education, Lordship, 1 and 2,
learned standing counsel, higher education, appears for respondent numbers 1 and 2,
Lordship.
and prays for 3 weeks' time to obtain instructions and to file counter affidavit
Lordship.
in the main writ petition.
Lordship.
Stop. As per the Lavazimo report dated 2/5/2025, notice upon the respondent numbers 3, 4, and 5 in the IA is complete. Considering the report made in the postal tract consignment. Stop, in view of above, notice is accepted to be complete on respondent numbers 3, 4, and 5. List the matter again after 3 weeks in the admission column. Respondents to file their counter
The
affidavit.
date may
in the
be given,
meantime.
otherwise it will not come, my lord. Any date, my lord.
That's the thing, that we have overruled, they thought they may be.
Mr. D. Bhattacharya, learned counsel, appears for respondent number 3 and submits that respondent number 3 is not a necessary party and should be struck off. However, the same will be considered at the appropriate time.
Date my.
Give a date after 3 weeks.
Obliged.
Just after 3 weeks on 16 June. Huh? Yes, Mr. Mahmood.
My lord, I was the headmaster of an ME school, kindly see page 9, madam.
Yes.
No, you tell me which order is not complied with. We're not,
Yes, that lordship may kindly see
we're not going for hearing.
order page 15, because my lord, case is otherwise very important, because on 31st May, I am
Para
going
8 and
to,
para 9.
my lord, I am going to retire on 31st May, my lord.
Please show me the order which has not been complied with.
Yes,
That's all.
order, my lord, page 15,
Order dated 21/1,
21/1/2025,
operative portion.
40%, page 19, my lord.
Para 8 and 9.
Please read. Paragraph 8.
The counsels of the respondents submit that as the matter pertains to the appointment of an in-charge headmaster, wherein neither of the parties have the required educational qualification for appointment to the post of a regular headmaster, the matter may be remanded back to the Director of Secondary Education to take a decision as to whether the petitioner or the respondent number 6 should be appointed as in-charge headmaster of the Morikolong High School. In view of the consent of the parties, the writ petition is disposed of with a direction to the Director of Secondary Education to take a decision as to whether the petitioner or the respondent number 6 should hold the post of in-charge headmaster of Morikolong High School till a regular headmaster is appointed. The said decision should be taken within a period of 3 weeks from the date of receipt of certified copy of this order. So, my lord, this order was communicated.
And Lordship, we have taken the decision and this is the compliance order, Lordship. I have served a copy to my senior friend and also to the court. So we have found both the person, they are not eligible. So Inspector of School was directed to hold the.
But my lord, office memorandum says that the headmaster of any school has been amalgamated, my lord. If amalgamation is made, the headmaster of any school automatically becomes the actual headmaster.
See, the argument can go on, but in a separate forum, not
Yes.
in this contempt.
Yes.
There's an order complied,
Yes.
orders of compliance, whether it's right or not is a different thing.
That is.
They have
I
challenged
heard
this.
Mr. M.U. Mahmood, learned counsel for the petitioner, and Mr. S.M.T. Chisti, learned counsel for the sole respondent. Stop, this contempt petition has been filed alleging willful and deliberate disobedience of the order dated 21/1/2025, passed in WPC number 3215 of 2024, whereby the respondent's authority was directed to take a decision as to whether the respondent number 6 or the petitioner should hold the post of in-charge headmaster of Morikolong High School till a regular headmaster is appointed. Stop, Mr. S.M.T. Chisti, learned counsel, has produced order dated 18/4/2025, passed by the Director of Secondary Education, Assam, wherein it has been stated that neither the petitioner nor the respondent number 6 qualified to hold the post of headmaster, even on in-charge basis, and accordingly, the Inspector of Schools and NDC Nagaon has been temporarily allowed to act as headmaster in charge. Stop, considering the order passed, it appears that the order of this court has already been complied with. Accordingly, the contempt petition stands closed. Copy of the order dated 18/4/2025, produced by Mr. S.M.T. Chisti, shall be retained in record and marked as expired.
I have also submitted a copy to my learned senior friend, Lordship.
A copy of the said order has also been furnished to Mr. M.U. Mahmood by the learned counsel, Mr. S.M.T. Chisti.
Obliged, sir.
Obliged.
There is,
Lordship, may I pray that this matter be taken after 10 minutes? This matter. I need to obtain some instruction. First while.
All right, pass over.
May it please, my lord. Lord, sir,
Yes,
these are two interlocutory applications, my lord.
IA.
Yes, my lord. Your lordships on 6th December 2024, my lord, had stayed the suspension orders. The lordships recall, my lord, that order your lordships will find at page 15.
Page?
15. Lordships have page 15, my lord, at the foot of the
Yes.
page.
Yes,
Having regard to the projections made, this court is inclined to stay the notification of 30/11 and the so-called notice dated 30/11 till the next returnable date. This order, my lord, is followed by an order of 10th January at page 18, my lord. Page 18, Justice Unni Krishnan Nair, my lord. Foot of the page, my lord, 4 lines. Accordingly, the respondent authorities in the finance department are directed to take steps for issuance of consequential orders towards permitting the petitioner to resume her services. However, the place of posting of the petitioner on such resumption by her would be as one decided by the departmental authorities. And page 19, my lord. Consequential orders as would now be called for in pursuance of the directions passed by this court by the order of 6/12 shall be issued by the respondent within a period of 1 week. I mean, this order is taken up in appeal. And the appeal court dismisses the appeal on 19th February, my lord. That order, your lordships will first see at page 21. Page 21, your lordships has, my lord.
yes.
The second paragraph. This intra-court appeal is directed against the order dated 6/12 and 10/1/25. So this is dismissed, my lord. Please come to page 33, my lord. The lordships has page 33 at the top of the page. In the
Yes.
light of the discussions above, the court is of the considered opinion that the order dated 6/12/24 and the order dated 10/1/25, both passed by the learned single judge, do not suffer from any perversity or error apparent on the face of the record. It cannot be held that the discretion available to the learned single judge was not properly exercised. Moreover, in the absence of any affidavit in opposition being filed before the learned single judge, in spite of sufficient time being granted, this court would exercise self-restraint in this case in entertaining this appeal. And at page 34, my lord, the appeal is dismissed. But till today, my lords, these orders are brazenly flouted and violated, my lords, by the respondents here.
What is the matter regarding?
Well, the matter, my lords, was assailing, my lords, the orders of suspension and, my lords, a so-called notice initiating departmental proceedings, my lords, by the notifications of 30th November 2023. My lords, the entire proceedings are based upon, my lords, the one-man commission inquiry report, which, my lords, in my respectful submission, my lord, which I persuaded your lordships, was in violation of section 8B and 8C of the Prevention of the Commissions of Inquiry Act.
30/11 of 2023.
Yes, my lord. Your lordship stated
No, this is regarding the
suspension order
suspension order.
and show-cause notice initiating departmental proceedings. Both your lordships, annexures A and B, your lordships have state, my lord. Your lordship sees that order again.
Where are they orders?
Page 15, 16, my lord. Order, my lord, is in the writ petition if your lordships take, my lord.
Annexure A and B. is
Yes,
it?
annexure A and B, that,
In WPC 5862.
yes, my lord.
How many writ petitions are there?
There are 2 writ petitions, my lord.
Why? Same person?
No, there are 2 different persons, my lord. Similar orders, identical order. And your lordship will find, my lord, the suspension order at page 43.
5860.
Page 43, my lord.
Mm.
This is what your lordship state on 6/12.
This is suspension.
Yes, my lord. And page 46, my lord.
And this is show cause.
So-called initiating departmental.
Okay, this was state, then what were they supposed to do?
So once this is state, my lord, the order of Justice Nair, if your lordship state, my lord, at page 18,
Yes.
that you pass the consequential orders reinstating the petitioner. Because
Okay.
the suspension order has been stayed. Page 18, my lord, foot of the page. Accordingly, the respondent authorities in the finance department are directed to take steps for issuance of consequential orders towards permitting the petitioner to resume her services. However, the place of posting on such resumption would be the one decided by the departmental authorities. And please have 19 para 8. Consequential orders as would now be called for, in pursuance of the directions is passed by this court, by the order dated so and so, shall be issued by the respondent authorities within a period of 1 week from today.
Okay,
Now,
now then,
these are brazenly flouted.
then,
One other matter of concern, I'm just raising before your lordship, is that
then they took the matter in appeal.
yeah, appeal was dismissed.
And 19 February appeal was dismissed.
Yes, your lordship.
Now today, why is the IA filed?
The IA is filed, today, because your lordship also have page 42, 40. Just have there.
40?
I'm holding my horses till my colleague finishes. I'm on VC lordship to this.
Please
That's
have page
okay.
52
I'm
and
informing the
56.
judge.
52?
52 and 56.
Yes.
Now, what happens is this, this case is taken up for discussion, in the Assam State Legislative Assembly, and the statement is made on the floor of the House that we will not comply with this order, even if we are held guilty of contempt.
Where is that?
That, please have page 52. Something very serious, Your lordship will see, at the translation page 10, Your lordship has that,
Yes.
Today we have appealed on the right-hand side. Today we have appealed against the reinstatement in the High Court. After the High Court's verdict, we are also prepared to take the matter to the Supreme Court. We will not spare anyone. Only after the Supreme Court decision, we will as a government abide by it. There is no doubt about that. If anyone wants to discuss how the government has handled the case, they can do so in the High Court. Now, please have the next paragraph, Last 3 lines. Later, the division bench, please mark, this is that order of 19th February, of the division bench. Later, the division bench directed us to go back to the single judgment. So we returned there. Even after the High Court's order, we have not reinstated anyone, even if it means contempt. There is no precedent for this. Even after the High Court's verdict, we have stood firm and we have not reinstated everyone. And just have the last 4 lines from the bottom. The division bench instructed us to go back to the single judge. We have complied. We have not reinstated anyone. Not a single person has rejoined their job, nor can they do so until the Supreme Court give us the permission to allow them to join. We will go all the way. We will not reinstate everyone. And please have, the other part at page 56. So something very serious,
No, anything pending in the Supreme Court?
Nothing. The division, after division bench, matter is pending before the single judge. So please have page 56.
Yes.
Honorable Speaker, that after translation, page 15 in the middle, I do not intend to delve into the Supreme Court judgment. You yourself should see whether they set affidavit submission dates in the matter. Reasonable time is given for submitting an affidavit in opposition. I have courage. There is no question against my courage. I can even question the words of a High Court judge. I have no lack of courage. If you read the dates mentioned, you will realize there was an urgency. Even after 3 years, affidavits are not submitted. Look at all the dates in this case. You will see 2011, 211. This case has appeared in the High Court 4 or 5 times within a short span. Does a normal case reach the High Court this frequently? That is why I do not wish to comment further in some cases. Look at the dates. These are the dates in this matter. Read aloud. 1311. 1311 was when your lordship issued notice. 612 is when your lordship stayed the suspension order. 7-1, 8-1, 13-1. This case appeared in the High Court 5 times in 2 months. Has Priyanka Das, this is the applicant before your lordship, writ petitioner, Priyanka Deka, mentioned as Priyanka Das, become such an influential person that a case keeps appearing on the High Court stop list repeatedly. I am only saying that I am not entirely with this judgment. Public employment is involved and the future of thousands of unemployed youths is at stake. The High Court should have summoned the Chief Secretary, asked why no affidavit was submitted. This is not a case where a judgment will be delivered without an affidavit in opposition. The High Court should have summoned the Chief Secretary. If this order is issued by me, it will disrupt the entire APSC investigation and dishearten the youth. Coming before me and tell me why this affidavit was not submitted. Where was the time for submission? If dates are scheduled every 5 days, where will an affidavit come from? You yourself read out the entire sequence of date. That is why I do not want to refer to the matter. Today we have submitted the affidavit. So, my respectful submission is this matter. They are not only
what is this transcription from?
transcription or, the discussions which took place on the 3rd of March 2024 in the Assam State Legislative Assembly. This discussion, in my respectful submission, is in violation of the rules of business of the House. Rule 278, I have extracted that, if your lordships have 278.
Just a minute. This is you have an extra as an extra.
and rule 78, your lords, 278, your lordships will have, my lord. There are rules after rules which says, my lord, matter which is pending in a court should not be the subject matter of discussion in the house.
Okay, what are you seeking now?
So today I'm saying this, my lord. They are in violation of the orders of this court, my lords, of 6th December and 10th January. This appeal dismissed. They have brazenly, they continue to be in defiance of the court's order. Not only that, my lords, a discussion is held where even, my lord, the executive head says that we will not comply with the order. I'm not scared of contempt. My respectful submission is in such cases, my lords, in writ proceedings under Article 226, my lords, your lordships should direct, my lords, the respondents to first comply with the order before they are heard any further. That's the law, my lords, that in case, my lords, the contempt is so egregious, my lords, in a case like this, where, my lords, they are brazenly flouting and yet, my lords, they are before the court. The lordship should first tell them to comply with the order before, my lords, they are heard any further. That's, my lords, my respectful submission is, my lords, the courts have said that the party who is in default must first purge himself of the contempt before he is heard further. That's my prayer, limited prayer at page 11. Matter is fixed, my lords, on 29.
29 for what? Which matter is fixed on 29?
These matters are fixed, my lords, on 29.
As per which order?
This order, my lords, your lordships will see at page 7th April order at page 36 at 38. At 38, my lord. All the writ petitions are directed to be listed for final hearing and disposal as fixed items on so and so, with the understanding party will subsidize. So, my lord, let them file a reply, my lords. This application may be taken up on.
All the writ petitions directly listed for final hearing and disposal which is on 29.
Yes. So, limited prayer I am seeking is, my lord, your lordships may issue notice in this matter, my lord. Let them file a reply to be taken up on 29.
Lordship, I'll address Lordship and you.
Yes, you are done?
Yes, Lordship, I'd like to
Anything
address
else?
Lordship.
Mr. Chaudhary.
Yes,
my submission, my lords, is the position in law is, my lords, a party who, my lords, violates the order of the court with impunity, and yet, my lords, presents themselves before the court, my lords. Your lordships, my lords, under Article 226, can tell the party you first comply with the order because, my lords, it has the effect of questioning the majesty of the court. And such a contempt, my lords, impedes the course of justice. My lords, decisions are there, my lords, which says even an interim order without jurisdiction, my lords, has to be complied with.
No, but you have filed IA instead of contempt, isn't it?
Well, contempt is separate. Contempt is for punishment.
it is pending.
Contempt is for punishment. What I am saying, my lords, is this, my lords, that a party, my lords, who violates an order of the court should not be heard till they purge themselves of the contempt. Or they should forthwith comply with the order.
No, that's okay, but see, the normal course, if the orders are not complied.
Yes, but this also,
You
my
have to
lords,
file a contempt.
I will make it good, my lords, as a point of law, my lords, that a party before the court, if he violates the order of the court, my lords, your court can refuse to hear that party. And this, my lord, orders are passed, my lord, not for anything else, but to maintain the majesty of the institution. That you cannot, my lords, on one hand, brazenly defy the order, even if it's an interim order. The interim order has become final, my lord, with the order of the division bench dismissing the appeal. Till date, my lords, more than 4 months have passed, my lords. They have not complied with the order.
Okay.
So my respectful submission is, my lords, the matter, this application may be listed along with, my lords, the other writ petitions. Let them file a reply, my lords, to be heard along with it. I'm grateful.
All right.
May I
Mr.
address
Kohli?
Lordship?
Yes.
Grateful, Lordship. So, Lordship, since the majesty of the court has been brought into question, then perhaps in the writ jurisdiction, the petitioner's counsel should have brought to notice that the state filed a vacation of stay application, which is what is being considered by Justice Suman Shyam's court, in which on the 7th of April, the concerned order was passed. On that particular day, I may also point out, since both the counsels on both sides are identical, these very arguments were professed, in fact, in response to the quoting the Honorable Chief Minister of the state. I had pointed out that this is for the gallery, which my learned friend took much umbrage to. And then Justice Suman Shyam, during that detailed hearing, said since the arguments on vacation of stay and merits primarily would be identical, we will hear the entirety of the matter on the 29th and 30th. During this period, an application has come, which in today's world of copy and paste on computers is substantially virtually the same. So we have a vacation of stay pending, we have a contempt pending. Now a new application for directions has been filed. And in fairness, Lordship, if it had to be filed, it should have gone before that particular court because all the arguments are still going to be identical. Now, Lordship, that matter's coming up in merely 8 days from now, when we will have the responsibility of arguing it fully before Justice Suman Shyam. So I would respectfully say, Lordship, no notice should be issued today. Let the matter be shifted to that, because there then the concerned bench, which is dealing with the contempt, with the vacation of stay, and other things being substantially of the same arguments in this application, and our response already being there, the court will consider it. So it may merely be deferred to that day. And if my learned friend wants to take this argument of purging the contempt, which is being kept pending by the Honorable Judge already, to hear the full arguments on the 29th, this application can be considered then too. I would respectfully say, Lordship, and it is my duty to say so in the writ jurisdiction, that this attempt is to get conflicting orders or to get different benches to hear substantially the same matter, which of course, Lordship, I am entitled to put, and my colleague on the other side is entitled to refute.
Malab, sir,
All right.
may I say this? For my learned friend to say, Malab, this matter has come up before your Lordship because his Lordship is the roster bench. It is not that, Malab, we are trying to fix benches or get matters here and there. There is no matter, Malab, pending before Justice Suman Shyam. It came before Justice Shyam, Malab, once when the matter was listed before him. Earlier, Malab, the matter has come before your Lordships. Matter has gone before the Unni Krishnan Nair, Malab. It has traveled all across. So, my lords, there is nothing like that matter has been heard or something. Today, my lords, I have filed an application here saying that, as a matter of law, that the respondents who defy and flout the orders of the court brazenly ought not to be heard till they purge themselves of the contempt, my lords. This is the principle of law. I'll make it good, my lords. There are reported judgments which says that this is not, my lords, for the parties here. It is for the dignity of the court. It is for the majesty of the court. And look, my lords, how the discussion takes place in the House. Something serious. All I am saying is, Malad, let them file a reply. They don't want to file a reply. Well and fine, Malad. Your Lordship will issue notice and list it on 29.
Two things, Lordship, if I may respond. That these very arguments have been taken already on the 7th of April in that court, Lordship. And second, what I will point out, several other applications came up or matters came up before different benches. We pointed out the existence of the order of the 7th of April, and they have all again got tagged on the 29th on that particular day. So I will respectfully say, Lordship, that an application with substantially, if not identically, the entirety being put up today is something that could be considered by that bench. It could be transferred there. Rest, of course, we are in Lordship's hand.
In fact, Malad, my learned friend also should have said, Malad, this issue was brought in, Malad, in their application. They filed an application for vacation. I filed a reply. There, Malad, a view came from the judge that you have filed it with a reply. You bring appropriate proceedings. This is the appropriate proceedings to them. I got an application, Malad. Whether this application merits to be allowed or to be dismissed will be decided, Malad. Today, all I am saying is the Lordships will issue notice. Let them file a reply. They don't want to file a reply, Malad. Matter should be heard on 29th when my application will be taken out. That's what I'm limited.
Okay, these matters are not are to be listed on before a particular bench.
No,
or any direction.
No, Malad.
No, there is no such direction.
Or something.
No. Matters are coming.
It's coming as per the roster.
13th November matter came before your Lordship. 6th December matter came before your Lordship.
Right.
After that, the roster bench was 7th January was Justice Shyam. It came before Justice Shyam. 10th he was not available. So the matter went before Justice Nair. Matter has traveled all across. It's not a case, that we are hunting benches or trying to get matters to a particular bench. This is not a fair submission to make.
What was
I may just add, Lordship, just one thing, if I may.
In April,
the date is 29th.
What was the date?
Yes,
7th of April.
The April date your Lordships will see is 7th April.
7th of April.
Page 35.
7th April, what came up?
7th April, my lord, these writ petitions were listed.
Any
And the
order was
registry is
passed?
Yes, sir.
directed.
Page 37,
Yes,
I read that out, my lord.
Lordship may read the entire order. I would request, otherwise I can screen share it.
Mm.
And in that, there is a direction to the registry.
And this IA was for,
This IA was for vacation of the state.
I see.
That has till date not been decided, my lord. So in that vacation of stay application, my lord, these events take place. So I bring it to the notice of the court. The court was of the view that you have brought it in a reply to an IA. Even my learned friend's submission was that in a reply to an IA, my learned friend is bringing in all this. My lord. All those are available. Now my learned friend is saying, no, this matter was raised before the court. The court has kept it for 29. That's why, my lord, I filed this application, my lord, to bring on record so that, my lord, to obviate any technical objections, because I am, my lord, seriously pressing this application as a matter of law that the party who defies, my lord, the order of the
This
court should
contempt
not be heard.
And contempt is also pending, Lordship. In this, they are seeking purging the contempt. But there is a contempt also pending. So in this application, they seek purging of contempt. Separately, they filed a contempt application, which is also pending consideration on the 29th.
Where is that contempt petition?
What is the contempt? What is the contempt? What is the contempt number is?
Lordship, I stand connected.
Contempt-
I've just been
Contempt
instructed.
petition
Contempt is
number
not listed on
103 of
29th.
2020.
It's kept in the way. It's not listed on
It is
29th.
not
I
listed.
stand corrected.
Contempt is not listed.
No, it's not listed, but you have
But
filed
I think it's
contempt.
102.
Contempt, but after the filing of the
Contempt petition
all these
103,
developments are
Lordship.
No, is it to come up with the writ petition
No,
also?
No,
Contempt.
that
No.
order doesn't say. Contempt
The
is
order
not
doesn't
come.
say so, but it was argued on that day, and it was said that we will argue all
All
the
I'm
things
saying,
on that
my lord,
29th.
the contempt is for, my lords, to punish a person for contempt. This, my lords, I'm raising as a point of law before your lordships. I'll make it good that a party, my lords, in contempt should not be heard till
No,
they
I
file
understand.
them.
I understand that
I'm
you've
grateful.
already said that.
That's my submission.
But
It's a legal submission, my lords. I'll make it good.
I was not aware about the contempt. That's why I asked you.
Yes.
You should have filed contempt.
No,
So
contempt
the
is
contempt
already
has
there,
been
my
filed.
lords, but
It's filed.
these events are subsequent to the
Contempt is already there.
already there.
Filed, already
Yes.
filed,
Yes.
but it's not
Yes.
been tagged with
Yes,
the
it's not
these
been
bunch
tagged.
of writ
Yes.
petitions.
Yes.
And it was filed before 7th of April, just as a matter of record.
Okay, before 7th of April. And the IA, which was taken up on 7th of April, is for vacation of the interim order.
Stay.
Yes.
So we'll tag this matter also
Yes.
on
I'm
29th.
so grateful.
And let my learned friend, if he
Mm.
wants
The
to
main
proceed
matter
to-
is already tagged there, Lordship. It is the lead matter is in fact this matter.
If he doesn't
So
want to
in the
participate,
lead matter is before the court, and this IA can go there.
Had Mr. H. Chaudhary, Learned Senior Counsel, assisted by Ms. B. Chaudhary for the applicant, who submits that this application has been filed
prayer at page 11, my lords.
by the applicant stroke writ petitioner for a direction to the respondent authorities to comply with the interim orders dated 6/12/2024 and 10/1/2025 passed in WPC number 5862 of 2024, and to immediately purge themselves of the contempt before being heard in the matter.
Same one.
Of the learned senior counsel submits that both the orders dated 6/12/2024 and 10/1/2025 passed in the writ petition was put to challenge by the respondent authorities by filing
Writ appeal number 60 of 2025.
writ appeal number 60
Yes, of
of
2025,
2025.
which was dismissed on 19/2.
Stop. The said writ appeal was, however, dismissed by order dated
19th February.
19/2/2025 without interfering with the interim orders passed by the learned single judge. He submits that despite the same, the interim orders have not been complied with, and in fact, the matter has been taken up for discussion in the state legislative assembly
On 3rd March.
on 3rd March 2025. These are from the newspaper, is it?
Similar, these are the office of transcripts of from the official website, my lord.
Now, what about this newspaper clip you have given?
Yes, ma'am. That newspaper report, your notice will have at page 41. Just have 41.
Okay.
This reports everything, my lord.
The learned counsel submits that. The learned senior counsel submits that. In fact, a discussion of matter pending before the court, before the state assembly, is clearly in violation of Rule 278 of the Rules of Procedure and Conduct of Business in the Assam Legislative Assembly. The learned senior counsel otherwise submits that a batch of writ petition, including the connected writ petition to the instant IA, is scheduled to be listed on 29/5/2025.
Yes.
And therefore, the instant application may be also be listed on that day. The learned senior counsel has stressed on his submission that before the matter is proceeded in the writ petition, the respondents should purge themselves
I'm grateful.
of the contempt before being heard in the matter. Next para. At this stage, Mr. N. Kohli, learned senior counsel, assisted by
Mr. A. Roy and Miss N. Menon.
Mr.
Ankit
A.
Roy and Nimisha Menon. N. Menon.
A. Roy and Mr. N. Ahmed.
Miss N.
Miss N. Menon. Thank
Menon.
you.
Miss N. Menon.
Yes,
Yes,
And Mr. A. Roy.
A. Roy.
that's right.
Appears for the
Respondents.
Respondent state.
respondent state, and submits that the state had filed an application for vacation of the interim orders, invite IAC number 632 of 2025, which was taken up on 7th of
7/4.
April, 7/4/2025. The court, upon considering the respective submissions made by the parties, was pleased to direct all the connected writ petitions as well as the interlocuted application to be listed on 29/5/2025. And therefore, the instant interlocuted application filed by the applicants, writ petitioners, should be tagged along with the other cases, which is scheduled to be listed on 29/5/2025. And that no notice may be issued in the instant IA.
I have two more arguments, Lordship, that the contempt was filed before the 7th/4, which is pending consideration. And the second is that the arguments made in this IA is substantially the same arguments made on that day on 7/4, including referring to the Chief Minister's speech in the Assembly. That is the relevant part, because that's why I said notice should not, because this is the reason why the court has kept 29th for final hearing. I'm
The
requesting for
senior
those.
counsel further submits that in fact, the applicant has also filed contempt petition for alleged and willful violation of the court's interim order. And the argument advanced by the party concerned in the contempt petition as well as in the interlocutory application filed by the state. And even as on today in the present IA are similar. To stop, the learned senior counsel thus submits that pending consideration of the entire matter on 29 May 2025. Notice may not be issued in the instant case. Next para, I have considered the submissions made by the learned counsels for the rival parties. Stop. Having regard to the fact that the instant IA has been filed with a specific prayer for a direction to the respondent authorities to purge themselves of the contempt before being heard in the matter. A notice will require to be issued to the respondents so that they have the opportunity to respond to the contentions made in the instant application. So it is, however, made clear that the notice is issued without any prejudice to the respondent to raise any such grounds of objection which they may raise on the next date fixed, that is 29/5/2025.
Grateful.
Stop. Accordingly, let notice be issued. Returnable by 29/5/2025. Mr. A. Roy, learned counsel for the state, accepts notice on behalf of the state respondents.
Otherwise, Mr. Nath is also here.
Okay, Mr. D. Nath. Applicant to furnish requisite copies of the application within the course of the day.
I have a request, Lordship,
Yes.
is that more time may be given for reply, because in any case, the arguments will come up irrespective of the notice. We'll file it for completion of records. The arguments will remain the same, but we would like to respond to it separately. So a little more time may be given beyond the
Mr.
29th.
Kohli, since the matter is fixed on 29/5, let it come up on that day.
It'll come up on that
If
day.
required, if you require some more time, definitely you can renew
We'll
your
bring
bid.
it up.
We'll consider that.
We'll read it.
The respondents will be at liberty to file their objection to the IA list accordingly on 29/5/2025. What is the lead case?
Sorry, Miller.
That is,
Along with
the lead is
The budget-
WPC 1380 of 2025.
along with WPC
1380.
6191.
Actually, that's the order.
Item 63, Miller, 6191. 6191.
5862 is also there, isn't it?
58, yes. Just the writ petition with this IA is, Miller, item 63.
These are already clubbed together.
Yes.
So I don't
They
think
are
we
clubbed
require any separate order.
Yes, but in 6191, Miller, item 63 is a similar application, Miller, IA 1565, same order, Miller.
No, what is the case number which should be mentioned?
In
this
this
order.
5862, that's the lead matter, Miller.
5862 is already clubbed together
Yes.
with
that's
that other bunch of
Yes.
cases. So that's why not required.
Very well.
Okay, please the matter. on 29/5/2025, along with the other cases.
Yeah.
Since Lordship has recorded the submission with regards to the speech and it being in violation of rules, if Lordship may be pleased to just in my submissions include that I have said that these arguments were professed on that day with regard to the speech and the rules, because then that is for completion of my submission, Lordship.
It was professed on which date? On 7/4.
Yes, Lordship. The speech and it being in violation of the rules was also argued on the 7/4. So I just want for completion that the
Okay.
state's point was also
Please add one more
that
line.
in my submission.
Mr. N.
Yes,
Kohli
Lordship.
also submits that the argument raised by the learned senior counsel for the applicant that the matter was discussed in the State Legislative Assembly was also raised on 7/4/2025.
I'm grateful. So deeply obliged, Lordship. Grateful.
Include that, sir.
Yes. Well, 63 also same order, but it's just that the IA number is different and the writ petition is 6191.
Okay.
Orders are the same one.
Similar orders.
Same order, same
Yes.
date. I'm grateful. for that.
Deeply obliged, Lordship.
Yes.
Two IAs have been filed. One is 1236, 2025 for sufficient of the legal years of the deceased petitioner. And the other is 1268 for impediment of the parties, government parties. In view of the order dated 4/3/2025.
One at a time.
My lord?
One at a time. Let us take one at a time.
Yes.
IA number
IA number 1236.
1236 is for
Substitution of legal years of the original petitioner.
who is the original petitioner?
Original petitioner Uddasan Rakolita.
Hmm.
He has expired on 16/11/2024.
16/11.
2024.
Hmm. Then who are his legal heirs?
Hello?
Who are the legal heirs?
Legal years are
How many of them? Five of them.
wife Joymati Kolita, daughter Korobi Kolita, son Utpal Kolita, Anup Kolita, and Rahul Kolita. They are the legal heirs of the disease petition.
Altogether 5.
Yes.
Any objection from the other side? What's your good name?
My name is MD MS Ali, Muhammad MS Ali.
Had Mohammed MS Ali, learned counsel for the applicant, who submits that by filing this application, the applicant seeks substitution of the original writ petitioner,
Contempt petition. Contempt matter.
the original contempt petitioner, Sri Uday Chandra Kalita, who expired on 16/11/2024 by his legal heirs, namely
Joymati Kolita, my lord.
his wife and 4 sons, correct?
3 sons, 1 daughter.
His wife,
Wife Joymati Kolita.
1 daughter and 3 sons. So the learned counsel submits that since the cause of the action subsists, implement of the legal heirs of the original contempt petitioner is necessary. Mr.
B. Deuri.
B. Mr. B. Deori, learned counsel appearing for the
I'm for respondent number 4.
respondent number 4.
Yes. 1 and 5.
And Mr. R. Majumdar, learned counsel appearing for respondent numbers 1 and 5. There's no objection to the application. Stop considering the submissions made. And on perusal of the application, the prayer of the applicants to complete the legal heirs of the deceased Uday Chandra Kalita is hereby allowed. IA stands disposed of. Then, in view of the order passed today, in IA C number 1236 of 2025, allowing the implement of the legal heirs of the original contempt petitioner. The petitioners shall file the amended cause title in 2 sets before the registry of this court within 3 working days
7 days, my lord, I may be permitted, 7 days.
or within 7 days. Stop. The learned counsel for the petitioner shall also furnish requisite copies of the amended cause title to the learned counsel appearing for the opposite party. Then what is the IA, the other IA?
Implement of the government newly parties. In view of the order dated.
Lordship, may I? Lordship, Lordship.
In my para number 5, my lord,
Excellent.
I have.
Link there.
Yes, what is this?
Lordship, otherwise the grievance is met, your lordship. Only it is that the petitioner, he has to appear before the treasury office. Due to his non-appearance, the payment would not have, was not made. So in that circle, if they are impleted, let them go and appear. Not to implement the new parties because his grievance is met, your lordship. May peruse that page.
No, I don't understand. What do you mean by that?
Lordship, it says that Sri Uday Chandra Kalita, the petitioner who was contempt petitioner, has not appeared before the undersigned. In this regards, a letter was issued to Uday Chandra Kalita with request to appear before the undersigned. Therefore,
Undersigned means
has
treasury
not
officer.
processed for payment from this end. Your lordship.
Undersigned means treasury officer.
Yes, your lordship. Undersigned by the treasury officer. It is
So whom do you
made
want
to
to
the director
implead?
of pension.
Okay, whom do you want to implead by this IA?
As per order dated, in my petition, I have mentioned, my lord, in para number 5, the applicant's party stated that on 4/3/2024.
Oh, don't read, start reading. Just answer my question. IA is for impleadment.
Implement of the
Whom do you want to implead?
newly director, but as per submission made by the learned counsel on behalf of the.
Who is the
respondent
new
of court.
director? Who is the new director?
New director is, my lord,
What is his name?
We heard that.
the pension director.
Pension, we are here. Available with the instruction.
Kobesh Deka, my lord. Currently, he is acting as director of pension.
No. Now it is Richard Das.
Kobesh Deka.
But he was earlier in commission.
Come to your prayer portion at page 9 of your IA. Impleadment the name of respondent number 2, Jayant Narlikar, in place of earlier respondent Shyam Jagannathan.
All the respondents were made in my contempt petition. Hence, I have already cited all those names. my lord.
Oh, how have you drafted this application? You should mention just whom you want to implead.
My lord,
Who are those persons?
since in my contempt petition, all the respondents were made parties. Hence, I have again mentioned their names, who are newly appointed.
No, whom do you want to implead? Mention their names only. Why do you keep on repeating the same name of which you have already arrayed? So and so in place of so and so.
All the
Just tell me who are the new persons? New persons.
as per my knowledge, Kobesh Deka.
No, no, one is Jayan Narlikar.
Nalika.
Then,
Finance Commissioner, my lord.
then who else?
John Nalikar.
Suranjana Senapati. This also.
This also.
Then
Then phone number Bhavesh.
Bhavesh Deka.
Yes, my lord.
3 persons.
Here, my lord, 6 persons. Apurva Thakuria. And Sri Munindra Goswami.
Where is the name Apurva Thakuria?
5 number, my lord.
There is no 5.
Page number 6, my lord.
Oh, I'm reading at your prayer portion, page number 9. Ultimately, what you are seeking for is given in your prayer portion.
Bhavesh Deka.
Your
It is not well. Yes,
come to page 9.
yes, sir. I am sorry.
You have mentioned Jayan Nalikar, Suranjana Senapati, and Bhavesh Deka.
Bhavesh Deka.
Only 3 persons.
In my prayer portion, I have done mistake, my lord. I may be permitted to.
You withdraw and file a fresh one.
Lordship, it's my humble submission again, your lordship, the front page, your lordship. The grievance has been met. If he goes and appear before the treasury officer, his work is done. The payment will be made. The first page, second page, all. So it's a pension matter, so I'm just.
At this stage, what was his name? Counsel here.
MDMS.
अपना नाम तो
No.
MDMS.
B duty.
Yes,
B
B Diori. At this stage, Mr. B Diori, learned counsel, submits that as per the instructions received by him, late Uday
Return for making necessary payment to the petition along with integration.
Uday Chandra Kalita
Yes.
failed to appear before the treasury officer. Rangia Sub-Treasury, Rangia. And therefore, further necessary steps could not be taken for payment of the pension. To stop, he submits that if the legal heirs of the deceased appear before the treasury officer concerned, payment of pension would be resolved. Stop to this submission. Mr. Mohammed M.S. Ali submits that he'll take instructions from his clients. In view of above, this is the matter again after 2 weeks. You find out? And what about this IA? Should we dispose it of?
This substitution may be disposed of, and the other is other may be kept pending, my lord, because I have to make it correct. If the honorable court may permit.
You withdraw this if you file a fresh one, if you
My
want to. On the prayer of Mr. M. Mohammed M.S. Ali, IA C number 1268 of 2025 stands dismissed as withdrawn, with liberty to file a fresh one, if so advised.
Highly advised.
Hello, this matter was fixed today. The assumption that the petitioner would be retiring today itself. One instruction I had from the respondents university. The first paragraph, Lordship would find, as per rule, you will retire, the last line, as per rule, you will retire from the service of the university on 31/5/2025. Keeping this in mind, my lord. So the counsel for the petitioners, the senior advocate, my lord, he is not here today, was informed. And I have also received some documents from the university which I'm under instructions to place before the honorable court, my lord. Perhaps if lordship would have it on Tuesday, my affidavit would be on record and his presence would also be there, we can sort out the matter. Till that time, my lord, he is not demitting office because 31st is the date he has to demit. Till that time, he is there. And having it on Tuesday would mean, my lord, either 27th or 29th. The case, my lord, where the petitioner was saying that he's the director of one of the institutes of the Dismissal University is entitled to continue up to 65 years in the alternative, and also that he's entitled to some pay. No matter that he had entered into the service by not furnishing proper particulars and have not also got that before this honorable court. I have to bring an affidavit. I would just require 2 days time. I send the drafted affidavit, it comes back from Dismissal, I'll file it. So either on Tuesday or Thursday next week. Since he's there till 31st, he's not demitting office before that.
The other day, where was it?
No, because the petitioner had completed their arguments, there was a little insufficiency of time that it rolled over to the next day.
No,
Yesterday
no,
I was out of station and today
no, correct. I mean, he was supposed to demit office by 23rd or something like that.
yes, now the instruction of that I had placed today before lordship, it says that he will demit it on 31st of May.
On what basis he said 23rd?
Because my lord, he attains the age of superannuation on 21st. So 22nd, per their calculation, was the date he should have gone out. But our rules say that if on the last day of the birth month, he demits office. So it goes back to 31st.
That is what happens to normally
Normally, that is what happens.
government servants
Yes.
and
He follows
universities.
the
and
Assam
so.
rules, and therefore he demits office only on the 31st. If the matter can be taken up any day before that, I'll have my affidavit on record.
But for not those on the bench, it's 1 day prior to your birthday, you have to go.
My senior, my lord, was perhaps with that impression that 21st he attains the age, so 21st he goes out. That has been clarified now. I'll just bring one affidavit on record and then lordship would take up the matter on any other day.
Mr. R. Majumdar, learned counsel for the university, submits that as per the instructions he has received, the petitioner is scheduled to demit his office upon attaining the age of superannuation on 31/5/2025 bracket AN close bracket. Stop. He submits that such being the position, he may be given some time to file an additional affidavit to bring on record certain materials which would be relevant for consideration of the case. Considering the submission, let the matter be listed when
27th or 29th convenience. On a hearing day, I was pointing out. 31st is Saturday, any day before that.
Would have it on 27th.
Fine.
File list the matter on 27th.
Fine.
As the first item in the admission column. And as part head.
Deeply obliged.
Lordship, pursuant to the last order, your lordship, order has been passed by the Registrar of Cooperative Societies
directing the department to release the pensionary benefit of the petitioner. Your Lordship.
Hmm.
So I have the copy of the order.
So matter can be closed.
Yes, madam, only the application number 6345/23.
Hmm.
And here there I have challenged the direction of the government.
Hmm.
That is prayer in the prayer portion, your Lordship, page 21. What will happen to those who automatically, because there the government has said that
Have you given a copy of the order?
yes, madam, given.
So it says now, therefore, in consideration of the above and in
Yes,
compliance of
pensionary
the,
benefit is given.
is hereby ordered pension cells and so on, maybe take immediate action for processing and releasing the pension benefits, so and
Yes,
so.
madam.
So if you are terminated, will you get pension?
No.
So if you get pension, that means they will not take any action
Yes, madam.
in that part.
Yes, madam.
So
Whether that
learned legal remembrancer of the government has clearly opined that no action may be taken against so and so
yes, yes, madam.
post-retirement
Yes, madam.
in absence of any proceeding during his service. So we'll record this and dispose it of.
Yes, madam.
Heard Mr. B. Sinha, learned counsel for the petitioner, and Mr.
G. Bordello.
G. Bordello, learned standing counsel,
Corporation
Corporation Department, for the official respondents. Stop on 4/4/2025. Court passed the following order. Yeah, please abstract it. Today, Mr. G. Bordello, learned standing counsel, Corporation Department, submits that pursuant to the direction of this court, the Registrar of Cooperative Societies has passed an order dated 5/5/2025, wherein it has been stated that an opinion has been given to the state government by the legal remembrancer that no action may be taken against the petitioner post-retirement in absence of any proceeding during his service, and that the delay and lapses lie with the department, and therefore the pension benefits entitled to the petitioner may be processed in accordance with law. Stop accordingly. The pension cell, head office, Assam Cooperative Societies, Assam, Khanapara, has been directed to take immediate necessary action for processing and releasing the pensionary benefits due to the petitioner in accordance with the applicable rules and procedures. Stop considering the said direction, it appears that the writ petitions have been rendered infructuous. In view of above, the
Petition number 4, 4 may be disposed of.
which one?
4, item number 4, 6345. And other two may be allowed to withdraw money with the liberty to, if required, we may file.
Which one should be disposed?
That 6345.
In view of above, writ petition WPC number 6345 of 2023 stands disposed of as infructuous.
And 2 and 3 with the liberty to file money if required money, maybe withdrawn money.
Stop. In respect of WPC number 9441 of 2019 and WPC number 3182 of 2022, the same stands dismissed as withdrawn with liberty to file afresh. If so advised. Next para, the order dated 5/5/2025 produced by Mr. G. Bordoloi, Learned Standing Counsel, Corporation Department, is being retained on the record and marked as X for identification.
Obliged.
My lord, I am sorry making mention at this moment, my lord. My item number 39, my lord, has been called upon as the first item today, my lord. I am very sorry, my lord. I missed the board, my lord. So, my lord, it has been dismissed as a non-prosecution. Can the order be recalled?
You apply restoration. I have signed the order.
Okay. Obliged, my lord.
Maybe Lordship.
Yes.
Today they have furnished the copy of the affidavit in opposition to me, my lord. Whether it is filed or not, my lord. So matter will come after 10 days, my lord.
Counsel for the petitioner submits that he has received a copy of the counter affidavit today and prays that the matter may be listed again after 10 days. Now, as paid for, list the matter again after 10 days.
Date given. On a fixed date, my lord.
On so and so, give a date.
Blessed, my lord. On 2/5, 2025, Lordship. Standing Council has taken time to take necessary instructions.
Who is the standing counsel?
Today morning, I have given a copy. Lordship, this is a case regarding pension. Petitioner has retired from service as a principal of Silchar Dental College. Originally, he was the principal of Regional Dental College, Guwahati. There is a departmental proceeding initiated against him. Originally, he was suspended. There is a departmental proceeding has been initiated. And after retirement of service, departmental proceeding has been closed with an order that he will be give a punishment. Lordship will find at page.
That's okay, but who's appearing for the other side?
Other side, Lordship.
Any instruction regarding gratuity?
Regarding other benefits, my lord.
Leave encashment. What does it say?
All pensionary benefit.
The DME has asked to submit the proposals by 23rd, madam. So it will be processed immediately, madam. Yes, and leave encashment.
Submit by 23rd of May.
Only thing is, Lordship,
Hmm.
this document has already been sent by the director to the secretary. I've enclosed that document.
No, the secretary has now informed the director to submit it before 23rd.
Page 109. That has already been sent, Lordship, on 2/6/2021.
Probably, my lord, that has been sent back or for some clarification, my lord.
Page 109.
So now, my lord, it is processed and it has been asked to send, my lord.
Voting document.
We see lack of executive not.
Already sent.
All right, please write Mr. D.P. Bora, Lanet Council, Standing Council of Health Department has produced communication dated 20/5/2025, written by the Additional Secretary to the Government of Assam, Medical Education and Research Department, to the Director of Medical Education, asking the state authority to submit the proposal for release of GPF final withdrawal, GIS savings, and leave encashment in respect of the petitioner, along with non-withdrawal certificate by 23/5/2025, without fail. The Learned Standing Council therefore submits that pending submission of the said proposal, the matter may be adjourned for some time, so that he can get back to the court with up-to-date instructions. Stop this submission, Mr. S.K. Goswami, Learned Counsel for the petitioner, submits that. In fact, the Director of Medical Education, Assam, had already submitted the necessary requisite documents to the Special Secretary, Government of Assam, Health and Family Welfare Department on 2/6/2021. So be it as it may, having regard to the communication made on 25/2025, let the matter be listed again. On 4th of June.
The next week, my lord.
You want it next week?
13th, my lord.
Okay, listed on 13th June 2025. Mr. Bora shall inform the court about the steps taken by the next date.
Okay. Apply, Joseph.
Yes.
There is better 2 weeks time to obtain my instruction.
Yeah.
Weeks time to obtain my instruction, because these are all not contractual employees. Employees. They were engaged by the government, hospital benefit society, not by the government workshop. So they asked the reviewed orders dated 9/8/2024. Their contractual employees, their contract period must not have expired by any. So let me have the instruction.
May I please, your lordship? It is correct by the hospital. Your lordship, I have been terminated without any prior show cause notice in violation of Article 311 to your lordship. That's why your lordship was convinced and your lordship was pleased to pass an interim order directing the respondent not to fill up their post.
Now thereafter, the case has been listed several times and they were directed to submit their affidavit in opposition, your lordship. It is a matter of 22, your lordship. And the question of contextual, expiry of contextual, it doesn't come, your lordship. It is during the pendency, your lordship. So, your lordship, since the affidavit is not forthcoming, your lordship, what instruction they will take, your lordship? It is apparent from the record that I have been terminated without any prior spoken notice. So I pray for sitting aside the impugned order and your lordship. Maybe direct. And that post is still lying vacant.
So let him get instructions. We'll see.
The last chance, your lordship.
Yes, lordship, after 2 weeks, lordship.
Okay, as paid for by Mr. D. Pamanya, Learned
Yeah.
Counsel for the Standing Counsel Health Department. 2 weeks, further 2 weeks time is granted to obtain instructions in the matter. List the matter again
Highly obliged.
after 2 weeks.
Date mean
On so and so, give a date.
9/6.
That is a lordship.
Yes,
Lordship, the respondents were to file their affidavit in opposition as per the last order.
Hmm.
So the affidavit in opposition has not been filed yet.
Lordship, 3 weeks time more required, lordship, instruction received but not prepared. Kindly grant.
all right, as paid for further 3 weeks time is granted to the respondents for filing the counter affidavit. Yes.
Obliged.
May please, lordship. Lordship, the matter relates to promotion of the CRPF constable to the post of sub-inspector, lordship. The petition. Promotion of CRPF constable to his next higher post. lordship.
What is the post?
Next post is sub-inspector.
Sub-inspector.
The petitioner joined the service on 8/11/1998, lordship.
Hmm.
The-
Yes, madam, you are ready with this matter?
Yes, I have filed my affidavit, lordship.
Hmm. Are you ready for the admission hearing?
It's for next week.
Yes, lordship.
Next week, lordship.
Next week. Parties are represented by the respective councils and they submit that since the pleadings are complete, matter may be listed for admission hearing on a convenient date as paid for. List the matter on 9th of June.
9 June.
Yes.
Hello, we have already filed 2 affidavit, one affidavit filed by the deputy secretary, but to kindly see. Case 50. 11, case 52, paragraph 2. Filed by deputy secretary, Dr. Vatsala.
Pleadings are complete in this case also.
Yes, respondent number.
Lordship, the earlier direction, lordship, number 25/2/2025, lordship, it was directed to take instruction, lordship. And it's the board order, lordship.
That instruction was, my lord, on 19 February 2025. They have said, my lord, the petitioner, he has not completed, my lord, your for pension as he has voluntarily retired. To voluntarily retired, my lord, he qualified service is 20 years. So petitioner qualifying service 17 years, 8 months, 26 days. Non-qualifying service of 1,849 days, 9 days. Pertinent to mention here, the SP Shulipur submitted the pension proposal in respect of the petitioner by memo number 31st August 2023. On receipt of the pension proposal, AP headquarters by letter dated 11/9/2023 forwarded the same to the government to convey government instruction in that regard, as the said government servant has not completed the qualifying service for getting pension as per rule. In this regard, a recent communication was received from the government by letter dated 18 February 2025, informing that the pension proposal in respect of the government servant is under process. And the file is moved to pension department for their use. So that is the latest instruction, my lord. So let it be after 2 years, my lord. In the meantime, I will get it.
That instruction in 2024 version.
25 instruction.
The Director of Administrative Reforms and the Commissioner Secretary Finance Department has been implemented as respondent number 10 and 11.
Brilliant.
The
This
Finance
is as
department,
per
view- Finance department and personal B department view is necessary. So they are not party, mother. Paragraph 2, mother, our affidavit says,
Who is not a party?
mother,
Who is not a party?
mother, finance department and personal B department is necessary to consult, because he has not completed 20 years of qualifying service to get pensioned on voluntary retirements.
No, you are saying about the arraying of parties. So and so is not a party. Finance is not a party.
Finance is not party, mother.
No, but the court has made a party.
Not we have met party.
25 to 2025 order.
As per direction, we have amended the post title.
But their name is not.
You have submitted the amended cost title.
The lords.
Director of Administrative Reforms, as well as Commissioner Secretary Finance is a party now. 10 and 11.
10 and
You want some more time to instructions?
Yes, yes. Yes, please, I have name is shown, Malak, for finance department. I will inform him, Malak.
Lordship, I'll appear, Lordship, if on the basis of the instruction of my learned senior, I'll also get necessary instruction, Lordship.
That's paid for by the learned counsel appear for the respondents. Further 2 weeks time is granted to obtain instructions in the matter.
Lordship, can it get maybe
This will come on 5th. This the matter. No, this come on, not a short date. It'll come on 11th. This is the matter again on 11th of June.
Please, Your Lordship.
Yes.
Your Lordship, in this case, Your Lordship, the petitioner has been deprived of his revised pay and allowance and increment with effect from 1/1/1996, Your Lordship. In spite of being order issued by this honorable court in several occasions, Your Lordship. The respondent authorities have failed to comply the orders passed by this honorable court, Your Lordship. Affidavit has not been filed by the respondent authority.
My lord, my latest instruction is, my lord, from the department, as discussed was held with the learned advocate general in this regard. As instructed by him, a detailed note along with all court's order and other relevant documents have been sent to him for obtaining his views regarding regulation of service of Sri Vijit Chakraborty, the petitioner. The department will proceed further once the views of the learned advocate general is received. So sometime may be granted, because the advocate general perhaps has not sent the views.
Even Your Lordship, in this case, SLP has been filed, which has been dismissed, Your Lordship.
Okay, on the prayer of Mr. B.C. Jutia, learned counsel, learned senior additional senior government advocate. Matter stands adjourned for 3 weeks to enable him to obtain instructions in the matter. List again on 11th of June.
Oblations.
Yeah. Petitioner filed this petition, my lord, for confirmation of his service, my lord. The respondent is to file the affidavit, my lord, but not yet filed.
Who are the respondents here?
PWD, my lord. PWD and finance, my lord.
We'll give them some more chance.
My lord.
PWD and finance.
Yes, my lord.
Anyone appearing for the state? PWD?
Finance.
Finance, you're there, Mr. Chaliha?
Yes, Lordship.
What is the instruction?
Lordship, here we have forwarded the proposal, Lordship, to the PWD, Lordship. Lordship may grant us 2 weeks' time, Lordship. In the meantime, we'll, in consultation of PWD, we'll file our affidavit.
As paid for by Mr. H. Chaliha, learned counsel, appearing for the finance department. 2 weeks' time is, further 2 weeks' time is granted to obtain instruction on the matter. And to file counter affidavit, list again on 11th of June. All right, next case.
In view of advertisement, I had applied for the post of medical record officer. And accordingly, I had appeared in interview. Thereafter, a document verification also done by the respondent authority. Subsequently, by publishing a notice, the respondent authority said that due to tie of marks, they could not be appointed me. And thereafter, I had approached before this honorable court by filing a writ petition. In that writ petition, order was passed to consider for my appointment. Thereafter, the respondent authority had filed a review petition, which was also dismissed. Subsequently, by impugned order, they rejected my candidacy.
So, Bora,
I prayer for appointment.
what is the instruction?
My lord, apparently he doesn't have the qualification, my lord, as stipulated in the advertisement, my lord. So speaking order dated, he has challenged the speaking order at page 45. So the ground of rejection of his candidature is that he doesn't fulfill the required eligibility criteria as stipulated in the advertisement, my
You
lord.
file the affidavit then?
Yes, my lord.
You file the affidavit then?
Yes, my lord, I will file. But otherwise, the speaking order, my lord, is clearly says there.
Page number?
Page number 45.
He's challenging the speaking order, isn't it?
Yes, my lord. It is the second round of litigation, my lord.
Which paragraph?
Paragraph 1, 2, 3, 4. Fifth paragraph, my lord. Whereas out of these 2 selected candidates for document verification, no one had requisite training on medical record officer. Training on medical record officer requirement as per advertisement. Now, if your lordship comes to the advertisement at page 22, my lord. Page 22, my lord. So serial number 6 is the medical record officer. So minimum educational qualification is graduate in arts, science, commerce from a recognized board or university with medical record officer training from recognized institute. The second part he doesn't have, my lord. Apparently, my lord.
Lordship,
You have the qualification.
Lordship, this training is in service course. After getting appointment, I will get that training, which was annexure page number 46.
No, you answer the question. Whether you have that qualification of being a graduate in arts, science, or commerce with medical record officer training
Yes.
from a recognized institute.
Yes.
Do you have that or not?
Yes, no.
No, I have not, but at the time of publishing the advertisement, there is not available, the course was not available in whole country.
Huh? What do you
My
mean?
lord, he is trying to say that training course was not available, my lord. That is. So if that course was not available, he should have challenged the advertisement itself, my lord.
Now subsequently, page number 46, thus Government of India introduced this course, which is a in-service course. Page number 46 and a relevant page number 48. Page number 48, column 1, medical record officer, essential. The candidate should be employed. This is training.
Yes, what do you mean by this? Next to 12?
It is not possible to have the said qualification before appointment. Yeah, the said fact has already emphasized, well emphasized by authority. Page number 26, they have made document verification also. Page number 26. Page number 26.
Yes.
By this notice, they call the candidates for document verification. And after document verification, page number 28, the said post kept pending due to tie of marks. And thereafter, the respondent authority kept pending for more for long days. And I had filed RTI application. They replied, page number 32. Answer to question number 1. Post of the medical record officer is kept vacant due to tie of marks secured by the candidates. Subsequently, another candidate had employed in another department. And accordingly, this honorable court, case number 33, case number 33, passed an order relevant case number 35. From second paragraph, for the reference paragraph number 6 of the affidavit in opposition dated so and so of the respondent number 5 extracted herein below, that the answering respondent submits that in the meantime he has appointed as a government servant as assistant teacher in a regular post and posted in the Kutir Singimari LP School under Gaudipur block in the district Dhuburi, Assam, and as such he has no objection if the respondent authority appointed the petitioner.
All right. You see, Mr. Bora, I think you should file an affidavit, whatever
Yes,
it may
my
be.
lord. Okay, I'll file my lord.
Mhm.
Yes, that will be the end.
That's paid for by Mr. D.P. Bora, Lanet Standing Consular Department. Further 3 weeks' time is granted to obtain instructions and to file contract.
There is an interim order which we consider.
What interim order? Which date?
In the first date,
This has not continued. I'm sorry, I'm not continuing it.
May it please your lordship.
Yes,
This is an application challenging the termination of the service of the petitioner. And it is absolutely termination simpliciter without giving any opportunity of being heard, nor any notice, nothing more. So your lordship, the petitioner will kindly take up. Petitioner, your lordship, passed the ITI as electrician under the government of Assam, Directorate of Employment. Your lordship will kindly take up page 12, 1, 2. 1, 2. This is the certificate of your lordship, wherein the Indian Industrial Training Institute, that is ITI, has prescribed the petitioner to have passed. So this is the pass certificate, which is the provisional certificate, and that has been stated that the state government will issue the council with vocational training for the period from 2016 to 18. So he was given the certificate in 2018 September. So this certificate is there. That is why I'm just pointing this out, because that will come into the picture later on. Now what has happened, your lordship, the advertisement was issued at page 30. Page 30, the advertisement, I'll just read the paragraph, first paragraph. Online applications are invited from citizens of India as defined under Article so and so of India for filling up of vacancies of different grade 3 posts, technical or non-technical in existing vacant posts and newly created posts in the Directorate of Medical Education Assam and different medical colleges and hospitals as well as dental colleges, nursing colleges, paramedical institutes of the state under the establishment of the Director of Medical Education Assam. Grade 3 technical post. I'm giving this is a type copy. I'm giving only the relevant post. In this case, your lordship, it is blacksmith, grade 3 technical post of blacksmith. So it is an unreserved post. So here, the eligibility part, your lordship will see down. The statement showing the name of the post require qualifications, scale of pay, grade pay, other allowances, admission under the rules of the above mentioned post as shown. Next page. Grade 3 technical post, blacksmith, ITI pass certificate, oblique. This is an oblique, lordship will see that. NCVT certificate in blacksmith. So either your ITI pass certificate or NCVT certificate. These two are required to be your eligibility. Now your lordship will kindly turn to page 18, 1-8. 18 is actually the combined application form. This is a combined application form for 2 posts. The petitioner actually applied for 2 posts. One is with regard to the advertisement that has been given. That is for the post of blacksmith. And one is for the post of electrician. That your lordship will see in the department DME grade 3. Down in that particular application, your lordship sees in bold letter, department DME grade 3. Lordship has seen that?
yes.
Yes, there at the serial number 4, the parallel line 4, post of DME technical grade 3 blacksmith. So this application is with regard to the blacksmith part. There's another application by the same petitioner that is in department of DHS, health services, your lordship, Department of Health Services. That is also grade 3. They're also in serial at line number 4. It is for DHS technical grade 3 electrician. So the petitioner in fact applied for both the posts, and below your lordship will see his qualifications have been given, and ITI, his Industrial Training Institute, Dibrugarh, he has passed with a percentage of 85.5%. So he has the qualification and all. Now your lordship, what has happened? Page 19. So on this application and the qualifications given by the petitioner, he was called for the written test that your lordship will find at page 19. So this is so-and-so, roll number so-and-so. This roll number will be important. Later on, I'll come to that. And so-and-so has been called, your lordship. In the last paragraph, you are hereby directed to appear in a written test to be held at so-and-so on 29/5/2022 at 11 AM at 12:30 PM for the post of blacksmith of electrician under the establishment of Directorate of Medical Education Assam, Directorate of Health Services Assam, Directorate of Health Services FW, etc., etc. So he was called
on the basis of his qualification and for the written test. Now your lordship will kindly see at page 20, last paragraph. There, this is serial number 3, the last paragraph. There will be a single question paper for all grade 3 technical posts. Separate post-wise merit list will be prepared with the applicants as per the marks secured in the written test, and roll numbers of shortlisted candidates will be published for every post advertised for appearing in skill test document verification. So now your lordship, after this, page 21. This is the result. This is the result sheet. Here I am just reading that. This is for information of all concerned that the candidates who appeared in the written test for the grade 3 technical post under the director of so and so, so and so, so and so, dated so and so, dated so and so, and dated so and so, so and so, so and so. Under the following roll numbers have been shortlisted on the basis of marks secured in the written examination, and they are hereby directed to appear for skill test and document verification at Guwahati Medical College so and so, so and so. Here your lordship, the petitioner's name appears at page 22 in the column of blacksmith. Here his number is at the second one, 10315308. This is the roll number that I referred to in the admit card. So the petitioner's name is his roll number appears at blacksmith here. Now what has happened, your lordship? In page 24. Obviously, he was called for interview that has been given, your lordship, to verify all the documents and all. So he was called for interview, and ultimately the final selection list has been finalized at page 24 on 10/5/2023. Here your lordship, notice the name of the petitioner is reflected at page 25, blacksmith. His roll number is 10315308. So he is selected. So he has been selected after duly passing through the written test and after the interview and verification of all the documents. He has been selected. Now your lordship will kindly turn to page 27. Page 27 is the appointment letter of the. I'm reading all this because of the fact that the termination, your lordship, was on certain grounds which will come. 25th of May 2023, he was appointed. As per recommendation of the Recruitment Board of Health and Family Welfare Department in pursuance of government approval by letter dated so and so, the following candidate is hereby appointed to the post of grade 3 and vacancy as shown below is our name with effect from the date of joining and as per the scale of pay subject to fulfillment of the following terms and notarized affidavit so and so, so and so. And this is under the pension rules also has been indicated here. His name is shown, your lordship. The petitioner has been appointed, and thereafter, your lordship, he joined at page 29. He joined the services on 15/6/2023. Now, your lordship, then thereafter, your lordship, a series of documents I have annexed. These are the salary slips for the month of June. That is at page 31, 32, 33, June, July, August. June, July, I'm not referring all this. You're also just pointing it out. These are the salary slip for the petitioner for the period of June, July, August. And at page 34, your lordship will find his pension for under NPS scheme, because this is under the new scheme, new pension scheme. NPS has been considered, and his NPS scheme was also started by the department, your lordship. Please, I will not refer to all this. Your lordship, I'll take your lordship directly to page 44. This is the order which is under challenge before your lordship. 38/2023. In pursuance to order number so and so, dated so and so, employment of the following candidates are hereby cancelled with immediate effect. The petitioner's name is as serial number 1. Now, how can a regular employee who is selected and appointed, the government employee can be cancelled without giving him at least one notice, opportunity of being heard? Directly one line, you're cancelled. No, nothing has been given, not a single whisper why he has been cancelled, why not. Now you'll also be interestingly in the second page, next page, page 45, there's a certificate issued to the petitioner by the medical superintendent under which he was working, page 45, dated 28/9/2023. So that was, your lordship, about a month later. This is what has been given to him. This is certified, so and so was appointed against DME government appointment letter number so and so due to blacksmith activities not functioning in Tezpur Medical College and Hospital. So he was allowed to work as technician electrical in Tezpur Medical College Hospital. He was terminated, released from his duties as followed by DME's order number so and so. Is this a ground, your lordship, for dismissing a person? This is also not a ground. Just because there is no blacksmith activity functioning, he was allowed to function as electrician. Now he was terminated because the order that dated so and so states that his candidate has been cancelled. This is the ground, your lordship, on which he was cancelled. Now, in the affidavit filed by the respondents, your lordship will find the affidavit starts from page 46. Page 46, your lordship. I'll read just one paragraph. At page 48, paragraph 5. Page 48, paragraph 5 is what I'll just point out, your lordship. The answering deponent begs to state that the advertisement, appointment, and placement procedure for the post of blacksmith was made by the Director of Medication in Assam, dated so and so. The petitioner was appointed as blacksmith and joined Tezpur Medical College Hospital on so and so. However, pursuant to the order number so and so dated issued by the director, his appointment was cancelled with immediate effect by the answering department as he was not having the requisite qualifications of ITI pass certificate / NCVT certificate in blacksmith. It is also relevant to mention herein that the certificate submitted by is not ITI pass certificate NCVT certificate in blacksmith as required by the advertisement dated 11/9/2021 issue. Now the question here, your lordship, is they have in the advertisement stated as ITI pass / NCVT. He has submitted his application. He has submitted the document. He has appeared in the written examination. He was called for interview, and he was also called for verification of his documents, and everything done. He was appointed, and in their reason of cancellation, they have stated that since he was working, since the post of blacksmithry was not functioning, therefore he allowed so and so, and ultimately that he was cancelled. Now they are coming up with a new story that he doesn't have. Why? How you have selected the person who is not even eligible at that point of time? You have verified his document. You have called for interview. He has taken all throughout. It was accepted. Suddenly in the affidavit, while they file, they say you are not qualified because you don't even have a qualification. But it's not, because he has already annexed his ITI qualification certificate. That I have already mentioned, your lordship, shown the certificate. So this is the ground. Now what has happened to your lordship? Your lordship knows the law. At least government servant, whatever be the reason, if he is terminated or he's a government employee, he has to be, there has a procedure which is prescribed under Article 311. At least a notice is essential. Whatever way, your lordship, if it's a regular post, if it is a contractual post, if it is the termination on the end of the contract, there won't be any problem. But if it is a post, regular post, substantive post, you are terminating him, whatever be the reason, at least one notice has to be given. That is not given, therefore this termination itself is not valid, your lordship. Now, your lordship, I will also rely on two judgments. I rely on two judgments of the Honorable Supreme Court in such cases, your lordship. Judgment kita di dia. One is a 2010 judgment and one is absolutely a recent judgment. So 2010, I first refer, your lordship. Kindly take up, this is a judgment of Kamal Nayan Mishra versus State of Madhya Pradesh to 2010 to Supreme Court 169, SSC 169. Here, your lordship, I'll just take your lordship to para 15, 15. Similar question was there and the court's issue. para 50. Our equation 2. So this is a confirmed government servant is the holder of a civil post entitled to the benefits of the safeguards provided under Article 311 of the Constitution. On the other hand, this is with regard a probationer that is not required here, but I'm still reading the whole paragraph. On the other hand, the probationer does not have any substantive right to hold the post and is not entitled to protection under Article 311. A probationer's service can be dispensed with during the period of probation or the end of the period of probation if the service is found to be unsatisfactory or is found to be unfit for employment. But in this case, he is not a probationer, Your Lordship. In this case, he is a confirmed government servant and holder of a civil post, and therefore all the benefits of safeguards under Article 311 of the Constitution is applicable in this case. Now, Your Lordship will kindly turn to paragraph 21. No term in the attestation form nor any consent given by a government servant can take away the constitutional safeguard provided to government servant under Article 311 of the Constitution. Just before that, I'll just point out one thing, Your Lordship. In that case, in that case, there was a something given by the petitioner in his application which was not correct. Therefore, this case was there. So therefore, in the fact of that case, it was stated, but in that case also, the court held no term in the attestation form nor any consent given by a government servant can take away the constitutional safeguard provided to a government servant under Article 4. Now, whatever be the reason, 311 of the Constitution is mandatory for a government servant. Now, Your Lordship will kindly turn to para 24. The determination of the appellant without an inquiry or hearing was illegal and invalid. In the normal course, we would have set aside determination directed reinstatement with consequential benefits, reserving liberty to the employer to initiate disciplinary process. But the peculiar facts of the case require us to adopt slightly different approach to do complete justice between parties. And therefore, para 26, we accordingly allow this appeal, set aside the judgment of the learned single judge and division bench. The writ of petition filed by the appellant before the High Court is allowed. Setting aside determination, the respondents are directed to reinstate the appellant with continuity of service and so on. So here, the court, I was going into only one point, whether a regular government servant is entitled to protection or safeguard under 311. In a case in hand, he's a regular servant, he's entitled to that. Now, Your Lordship will kindly take the next judgment. This is the judgment, this is the judgment of Honorable Supreme Court in Swati, Priyadarshini versus the state of Madhya Pradesh. This was decided on 22nd of August 2024. I'm giving the printout copy, Your Lordship. The citation part I have not got it. So this is a reportable judgment, but I haven't got it. Now, Your Lordship will kindly take up para 34. I'm reading only one para. I'm not going into the facts and circumstances of the cases, but I'm just pointing out. And this paragraph, Your Lordship, refers to one of the leading judgments in this field, Your Lordship. Para 34, Your Lordship will find at page 18. Page is at the top of the, pages are shown at the top. Page 18, paragraph 34. May I read, Your Lordship?
Yes.
It is in here, Your Lordship, what the court has stated in what grounds 311 and notice are mandatory. That has been stated. It is profitable to refer to what 5 learned judges of this honorable court laid down in Purushottam Lal versus so-and-so, so-and-so, so-and-so. The position may therefore be summed up as follows. Any and every termination of service is not a dismissal, removal, or reduction in rank. A termination of service brought about by the exercise of a contractual right is not per se a dismissal or removal, as has been held by this court in so-and-so versus so-and-so. Likewise, termination of service by compulsory retirement in terms of specific rule regulating the conditions of service is not tantamount to infliction of a punishment and does not attract Article 311(2) as or has also been held by this court in so-and-so versus so-and-so. In either of the two aforementioned cases, the termination of service did not carry with it the penal consequences of loss of pay or allowances under Rule 52 of the Fundamental Rules. It is true that the misconduct, negligence, inefficiency, or any other disqualification may be motive or inducing factor which influences the government to take action under the terms of the contract of employment or the specific service rule. Nevertheless, if a right exists under the contract or the rules to terminate the service, the motive operating in the mind of the government is as so-and-so has said in so-and-so versus so-and-so, wholly irrelevant. In short, if your lordship, the bold ones are important. In short, if the termination of service is founded on the right flowing from contract or the service rules, then prima facie, the termination is not a punishment and carries with it no evil consequences. And so, Article 311 is not attractive. But even if the government has, by contract or under the rules, the right to terminate the employment without going through the procedure prescribed for inflicting the punishment of dismissal or removal or reduction in rank, the government may nevertheless choose to punish the servant. And if the termination of service sought to be founded on misconduct, negligence, inefficiency, or any other disqualification, then it is a punishment and the requirements of Article 311 must be complied. Here, your lordship, we can take it as other disqualification, which they may say I am not qualified or something. They are saying that. So that is case where 311 must be complied with. Further, I'll read you. As already stated, if the servant has got a right to continue in the post, then unless the contract of employment or the rules provide to contrary, his service cannot be terminated. Otherwise, then for misconduct, negligence, inefficiency, or other good and sufficient cause, a termination of service of such a servant on such ground must be a punishment, and therefore a dismissal or removal within Article 311, for it operates as a forfeiture of his right, and he is visited with the evil consequences of loss of pay and allowances. It put an indelible stigma on the officers by affecting his future. This second part, I'm not reading here, your lordship, this page. I'll go to page 21. Because that part is not connected in basically with this case. Page 21, again, your lordship will see the bold part. I'll read. The first bold part is gone, second bold part. In spite of the use of such innocuous expressions, I'll read from there. The court has to apply the two tests. This is important. Mentioned above, namely one, whether the servant has a right to the post or the rank. Now here is the right to the post and the rank. Or whether he has been visited with evil consequences of the kind herein before referred to. If the case satisfies either of the two tests, then it must be held that the servant has been punished and the termination of his service must be taken as a dismissal or removal from service, or reversion of his substantive rank must be regarded as a reduction in rank. And if the requirements of the rules in Article 3, if the requirements which give protection to the government servant have not been complied with, the termination of the service or reduction of rank must be held to be wrongful and in violation of the constitutional right of the servant. This is emphasis supplied, and on the basis of that judgment, your lordship, at para 36 of this judgment, court holding it in view of the discussions mainly, the MPN judgment is quasi and set aside. So my whole case is that here is the case. I am substantially appointed. I am not a contractual employee or such. Substantially appointed after going through the interview, written test, everything, and also verification of the documents. Then I worked, my salary is paid, my pensionary benefits have been accrued. Now, suddenly you issue a letter without anything, no notice, nothing, no grounds, nothing. And after a month or so, another certificate was issued to me that there was no black mystery work, and therefore I was working as in the post of electrician, and now I am terminated. What kind of your lordship termination is this? Can it sustain your lordship under this circumstance? This is my case.
What is the ground of termination?
Lordship, the ground of termination is very clear, Lordship. He was not having the requisite qualification, Lordship. That is the Lordship, that is the certificate at page 12, Lordship. It says, Lordship, he has ITI certificate, but it is for the electrician, Lordship, and he applied for a blacksmith post, Lordship, which is totally different from that of an electrician's post, Lordship. So that is the ground. And regarding notice, Lordship, whether it was issued to him or not, Lordship. Just, Lordship, an hour ago, Lordship, I have received instruction in this matter, Lordship, from the DME office. Lordship, I have filed affidavit from on behalf of the respondent number 4, Lordship, the principal. From the DME office, I have received instruction that notices were issued to him before termination. So, Lordship, may I pray that this matter may be taken up on Monday, Lordship, because I have telephonic instruction. Let me place the notice, Lordship, in the form of an affidavit. Lordship, the principal of that college, Lordship.
And who has given the notice?
It's the Director of Medical Education. He is the appointing authority, Lordship, on whose direction, Lordship, that impugn order was issued, Lordship.
All right. Monday,
Lordship.
Mr. Y. Manan. Y.S. Manan, learned counsel for the petitioner, submits that the petitioner has been terminated from service without affording him any opportunity and without giving him any notice. And therefore, the same is not sustainable. Stop Mr. D. Upamanya, learned standing counsel, Health Department, otherwise submits that as per the recent instruction he has received, the petitioner was indeed given notice, and he may be given some time to file the instruction by way of an affidavit. Considering the prayer, let the matter be listed. Monday or Tuesday?
27th will be better.
27, Lordship.
On 27th of May 2025.
Highly
Health Department to file the affidavit on or before that date.
Obliged.
Yes.
My lord, this petition is praying for consideration of the petitioner for compassionate appointment. On the last occasion, my lord, an affidavit was directed to be filed. Time was granted, my lord, on 24th of March 2025. That affidavit will be necessary, my lord, for adjudication of the issues.
I will file those. I'll fix the matter of the 2 weeks, also I will file within that.
Mr. G.K. Goswami, additional senior government advocate, seeks further.
Standing counsel APDCL here. Herein I am stand as a standing counsel APDCL.
Okay, Mr. J.K. Goswami, learned standing counsel, APDCL, seeks further 2 weeks time to file the counter affidavit. In view of above, list this matter.
If my lord can kindly fix a date subject to your lordship's convenience, maybe a week thereafter, so that it enables us to also file a rejoinder if needed. After 3 weeks might be a lot.
Matter be listed on 16th of June, 2025.
I'm grateful.
This case, no affidavit has been filed by the respondent. Earlier 2 occasions, seeking time to file affidavit. However, the husband of the petitioner died in the year 2013. Till that, no family pension has been granted.
What is the case about for family pension?
Family pension. The
Who is before the court? The wife. Husband was working as what?
Gaon Panchayat secretary. And he joined on service 2/12/1993, and thereafter regularized on 10/6/2003, and subsequently died on 11/9/2013. After death, kindly see Annexure 6, page 39. The respondent paid the leave salary, encashment, and gratuity, but no family pension has been granted till death.
Yes.
Lordship, in a similar matter that the petitioner cited, that is Writ Appeal 133 of 2023, against the Writ Appeal 133 of 2023, against the judgment which the state have preferred an IA for clarification as to which date is to be considered for counting the qualifying service period. The IA came up yesterday and the order was passed, but we are not satisfied with the order. We'll be filing a review against the said order. So some time may be given after that this petition may be taken up.
The already finalized by before the Supreme Court, Supreme Court return back the issue, my lord.
So the Supreme
And
Court have,
yesterday, clarified regarding date of regularization,
yes, so we are.
whether it is 2006 or 2003. Kindly peruse the order, my lord.
So which one is the date?
Madam.
So we'll be filing a review against the order that was passed yesterday against the IA.
So what has been accepted ultimately? Which year?
My lord.
10/6/2003.
Then
The
say 2003.
regularization is to be taken into consideration. So we'll be filing review as to which date is to be considered for determining qualifying service. So initial date of appointment or the date of regularization.
Ten six 2003.
Then, my lord, I am entitled family pension, my lord, under old pension scheme, my lord. And 12 years, my lord, he has lingering the case, my lord. Writ appeal after, my lord, Supreme Court remand back the matter, my lord. And thereafter, filed IA, my lord, and now going to file review, my lord.
You are planning to file a review on the IA.
Yes.
But you are yet to file, isn't it? How do we adjourn the matter in anticipation of you filing?
3-4 weeks may be given, will be by that we'll try. Because the division bench was also not a regular division bench as much as I'm aware.
Mr. K.R. Patgiri, please write on, submits that in view of the order passed by the division bench of this court in IAC number 237 of 2025. Clarifying that ten six 2003 would be the date for regularization of service, the instant petitioner would be entitled to pension as per the old pension rules. Your good name?
A.K. Ghosh on behalf of Mr. S. Datta
Mr. A.K. Ghosh, learned counsel, appearing on behalf of Mr. S. Datta,
for PNRD department.
representing PNRD department, submits that the respondents are contemplating filing of a review petition against the order passed of the IA and pending the same, pending the filing of the same, the filing and consideration of the same, the instant petition may be adjourned for 4 weeks. In view of above, that the matter be listed again after 4 weeks.
Nice, no,
All right.
In this matter, my lord, pleadings are otherwise complete. Pleadings are otherwise complete.
So when?
The issue in a nutshell is that, my lord, the selection process that was initiated was abandoned midway on account of a policy decision taken. That is what has been challenged. He had this, the petitioner had cleared up to the first round. His name figures in the list of candidates for the published so far as the written examination is concerned, the computer-based examination is concerned. It was at that stage the selection process was abandoned. His question is whether he has any right at all.
That's it. In the midway, the recruitment process was stopped. In the same advertisement, some candidates got their appointment. But some categories of candidates, they have been deprived as because in the midway, due to the administrative decision, this appointment process were withheld, but no reasons were cited in the notification dated 21/01/2022 in page number.
This notification was not withdrawn in toto, only partial
Partial. Some categories.
in respect of some
Some
categories.
categories. The
And
current,
in respect of other categories, it proceeded.
oh, yes,
Okay.
they got appointment.
See, the-
38 page number.
All right, see, the pleadings are complete. We posted for admission hearing on a date agreed to by the parties.
In that case, let it be on a hearing day, that way it will be.
Please write down, parties are represented by their respective councils and they submit that the pleadings are complete. We have above and as paid for, let the matter be listed on 12th of June for admission hearing.
12.
Yes. Thursday.
Other date, maybe 13 maybe, 13 June.
13 is not a hearing date, Mr. Council.
Other date,
17th then?
maybe.
In that case, my lord, can it be 19th, 17th, 16th and 17th, I'm likely to be in Itanagar.
Okay, 19th.
Let's see.
Mr. Council, we cannot fix dates at your convenience
Except
every
Thursday.
time.
Let's see, except Thursday, any date may be given.
Why? You have
Some-
problem with Thursday?
Yes, Thursday. As per our learned council.
In
Except
that case, my lord, 24th of June. 24th.
maybe
no.
given.
He's come with his big diary and
Thursday, except Thursday.
what's wrong with Thursday?
Problem difficult.
I see. Thursday you don't go out.
Strong superstition against Thursday.
Okay, leave this matter on 24th of June for admission hearing as paid.
Obvious. I didn't read you on.
Next legal lawsuit. As per the last order dated 25/4, my lord, the learned government advocate was allowed 2 weeks time to file counter affidavit, my lord.
They have not filed.
Affidavit is filed, my lord.
When?
It was filed out, my lord, 19th January 2025.
No, not that, man. After that, my lord, there is another development. The lawsuit may be pleased to see the order dated last order, my lord, dated.
Correct. See,
24
February some affidavit was filed.
No,
In
no,
March, some additional affidavit was filed. Then thereafter, one more order in April saying that they'll file counter affidavit. By respondent number 2,
yes, my lord, director.
somebody has filed affidavit. Who's this?
As per the 4 filed. My lord, petitioner has no case, my lord, otherwise. Lordship kindly see additional affidavit filed by the petitioner, page 141. Page 141. Additional affidavit filed by,
141, yes.
yes, Lordship kindly see this is notification, my lord. This is a letter, my lord, written to the child development project officer regarding proposal submitted. Nutshell, my lord, fact is this, my lord, they are working as a Anganwadi worker and helper. They retired. And there is some beneficial retirement terminal benefit is given by the government by notification.
Page 102, my lord.
Yes, but I am reading whole similar. With reference to subject cited above, and in pursuance of the Honorable Guwahati High Court Order 6/1/2025, passing WPC number 2101/2024, Hira Hazur and 15 others, and others proposal for terminal benefit which was submitted from your end on 20th December 2004 has been examined at the Director of Women and Child Development Assam. According to the proposal, details of retirement, termination, resignation from the service in the respect of 16 numbers of petitioner desire. All are terminated and retired in 2016 and 17. And next Lordship, 142 page Lordship policy. Government has introduced the terminal benefit scheme to Anganwadi workers and Anganwadi helpers by notification dated 1/4/2022 on attaining the 60 years of age who have rendered continuous honorary service for minimum 10 years. The said government notification came into force with immediate effect, which implies that the notification was effective from 1/4/2022. But from the proposal, it has been found that the petitioners were not in the service at the time of publication of a notification 1/4/2022. Hence, the proposal dated 20th December 2024 submitted for release of terminal benefit of 16 numbers of incumbents cannot be considered as the government notification dated 1/4/2022 for terminal benefit does not allow to give it a retrospective effect. The scheme is introduced 2022. They were retired before that 16 and 17. So they are not entitled. This is if they want to challenge it, they can challenge it. But in this representation, this data is not challenged. So petitioner is otherwise not covered. This is a notification only with effect from 1st April 2022. But they are retired. Notification, the chart is there. All are retired. Page 141 to 142 chart is there. The 15 numbers. All are retired before that. 2017, 2016, 2015, 2012, like that. 2014. How they are covered? Not covered.
Yes, what we say?
My lord, kindly see your lawsuit, page 147, my lord. Order of this number code dated 14/2/2025. My learned friend has read out the letter forwarded by the director. After that, there is an order passed on 14/2/2025. And following that order, I have filed an additional affidavit. Your lordship may be pleased to see the additional affidavit I have filed. It is at page 133, Mal.
133.
What is 147?
147, my lord. The letter that is read out before your lordship, my learned friend, it was considered by this honorable court, then the honorable court was pleased to pass this order, my lord. That is, it is submitted by Mr. D. Bora, learned government advocate, that a recommendation of the CDP or the Kuakana ICADS project Lakhimpur in favor of the petitioner for grant of terminal benefit was considered by the director. The director by its order dated 1/2/2025 has rejected such claim. A copy of such order be furnished to so-and-so advocate for his personal response. A copy of the order date is also kept on record as marked as X. List the matter again after 3 weeks, so on the date fixed by the owner registry. Thereafter, my lord, following this order, I have filed my additional affidavit page 133, my lord. In this additional affidavit, while explaining the learned director's order, my lord, I have also referred to the government notification page 102.
See, are you not supposed to impugn that communication? By filing additional affidavit, can you challenge like this?
Cannot.
And on this affidavit, my lord, I'm a government advocate on the last order, as I drawn your lordship attention on page 25/4/2025. They made a prayer to file counter affidavit.
Perhaps
That
the
has not been
learned
filed as
advocate
yet.
at that moment did not point
Therefore,
out this thing.
This time was allowed, they did not file it. And now my learned head, without filing the counter affidavit, he has taken a different stand.
His records, my lord, his documents, my lord. I am submitting from it, whether he is eligible or not. My answer is this. Page 141 and 42 is the answer. So what remains in the writ petition, my lord? Why affidavit is necessary? Until and unless it is challenged by the petitioner, we will not file any more affidavit. Yes, CDPO forwarded their proposal. That has been considered by the director and returned to the CDP. They know we cannot consider there because they are not covered by this notification. Notification is with effect from 1st April 2022. Hence, the day retired in the 2019, 17, 16, 12, 14. How they will be eligible? Not. After that, the person is terminated or not resigned or not superannuated, they will be benefited. They will be not benefited, my lord.
Okay, where is this 2022 thing? Is it this
My lord,
document?
Your Lordship may be pleased to see the notification whereby the one-time terminal benefits was for page 102.
102.
Page 102, Annex 3, my lord.
102.
Yes.
The governor of Assam is pleased to notify that the age of relinquishment of services of all Anganwadi workers in many Anganwadi centers and Anganwadi helpers shall be on reaching 60 years and their services shall be discontinued accordingly. It has been further decided to introduce a terminal benefit scheme whereby Anganwadi workers, Anganwadi helpers in many Anganwadi centers and Anganwadi helpers who have rendered continuous honorary service for a minimum period of 10 years will be entitled to get one-time lump sum amount of rupees 4 lakhs,
3 lakhs, 2 lakhs.
rupees 3 lakhs, and also rupees 2 lakhs respectively on relinquishment of services after attaining 60 years of age. In case of upgradations of incumbent from Anganwadi helper in Anganwadi worker, the services rendered as Anganwadi helpers will also be counted, provided that the services are continuous and without any break. In case of death in harness, the next of kin will be entitled to get the same benefit as above, irrespective of the tenure of honorary service. In case of disengagement from honorary service.
Okay, you please come to 104.
It will be come into effect, immediate effect. That means
104.
104, yes.
Last sentence.
It will come into force with immediate
It
effect.
will come into force and
Then-
So there is no retrospective effect.
Before that,
No.
before that one paragraph, you also can see, if any question arises as to the interpretation of these provisions, the decision of the state government shall be final.
Okay. So
And now the government advocate, considering this aspect of the letter, my lord, on the last occasion, it was submitted before the court, honorable court, and learned government advocate prayed for time to file counter affidavit. Government has so far not filed any affidavit. This affidavit was filed by the director. CDPO of the concerned district forwarded our name, providing that yes, they are entitled because the similarly situated person, those who started our job, they had the same job with us long back in the year 75, 76, my lord, and who were also terminated simultaneously with us, my lord. Some of them have been provided the benefit. As
Where
my
is
lord,
that? Where is
your
that?
lordship kindly see.
Where is
the
that?
Affidavit. The affidavit submitted by the CDPO concerned.
CDPO is not a matter of authority, the director is the authority. CDPO is a field officer.
CDPO has
Yes, he has.
forwarded the matter.
Yes, I have seen the affidavit, my lord.
No, just a minute. See, both of you don't argue together. Let him
Yes.
complete, Mr.
Yes, yes.
Sutia.
My lord, your lordship kindly see the affidavit filed by the CDPO, page 120 to 133, my lord.
What is there in that affidavit?
I beg to draw your lordship attention particularly to paragraph 4, page 121, my lord. Paragraph 4.
Oh.
With regard to the statement made in paragraph 6 to 7, the answering deponent begs to state that as per government notification dated 1/4/2022 issued by the Principal Secretary to the Government of Assam Social Welfare Department and the letter dated so and so issued by the Director of Social Welfare, the Child Development Project Officer, Dakwakana ICDS project, had prepared a list of 40 numbers of ex-Anganwadi workers and 21 numbers of ex-helpers and submitted a proposal to the Director of Social Welfare Assam by letter number 17/2022 for payment of one-time terminal benefits to the said 40 numbers of Anganwadi workers and 21 numbers of Anganwadi helpers who rendered their voluntary services in the respective Anganwadi centers under the Dakwakana ICDS project until the date of their superannuation. The answering deponent further state that the answering deponent has also joined his present place of posting on 8/3/2024 as Child Development Project Officer, Dakwakana ICDS project. So he does not know why the names of the present petitioners were excluded from the said proposed list of ex-Anganwadi workers and ex-helpers which were forwarded to the Director of Social Welfare Assam by letter number 17/2022 one-time terminal benefit. As regards the statement so and so, then my lord, paragraph 6.
Where
As
is
regards
this?
the statement,
Where is this 1/7/2022?
Assam letter dated 1/7/22 for one-time terminal benefits.
Do you have a copy of this letter?
My lord,
1/7/2022. Name was forwarded, but your name was not included.
we are similarly situated, my lord. Your lordship, by this letter, the director.
Where is the letter? Is it available here in the record?
No.
By this letter, some similarly situated persons' names were forwarded to the director.
So you have to show me this letter.
This letter is.
These persons are similar situated.
CDPO.
Huh?
It is mentioned in the affidavit of the CDPO. I am not supposed to get this letter. This letter is lying with the director. My learned friend may procure this.
No,
and also, my lord. Your lordship
since it's
can
beneficial to you, you should also try to procure it.
One thing, my lord, page 140. This affidavit filed by the CDPO Lordship kindly see 21 February 2025. 140 page. CDPO forwarding in favor of them file affidavit 21 February 2025. And next page 141, director with reference to his letter dated 28 December 2024 has rejected their proposal. How thereafter or rejected on 1st February 2025. 21st February 2025, how CDPO can, without going through this letter, file this affidavit ballot? How he can file this? Not that lordship see director reference it. With reference to your letter, 20th December 2024 has been examined. And the director Women Salary Assam accordingly proposal details retirement, termination, resignation from the service in respect of 16 of provisional are as follow. So this letter issued in 1st February 2024. CDPO filed 21 February 2025. How? Without going through this rejection letter is there. CDPO has not seen the rejection order. It is addressed to him. How we can believe that CDPO has gone through it, but how he can say this notification with effect from 1/4/2022 will cover there retrospectively? It is immediate effect. That means 1/4/2024 onwards, they will be get the benefit. This is a scheme. They are not rule. This is a scheme. Simple things, Balo. Director rejected it on 1st February 2025 and he filed affidavit 21st February 2025. After 20 days, he does not know. CDPO does not know about this letter. Without knowing this letter, he has filed this affidavit at the behest of the petitioners, forwarding it in favor of that. How it is possible, Bala? Not possible. I think affidavit is not necessary, Bala. If required, I will file. Kindly see. His affidavit CDPO filed for 21st February And this rejection is 1st February.
No, you are no mistake. When the direct, CDP filed the affidavit earlier.
See here. This one, which one? Or your additional affidavit, or your additional affidavit. Additional affidavit file. CDPO file,
Affidavit of 29/1/2020.
yes, 29 January 2025.
And director's letter,
1st February 2025. However, the CDPO.
So we'll do one thing. See, if you say that you'll not file affidavit, we'll like record that and post it for admission hearing then.
Yes.
That's what we can do at this moment.
so let them file the affidavit.
No, on the basis of that, I'll go.
If they don't want to file the affidavit, it's up to them.
And
But you-
director decision, my lord, I have referred your, drawn your lordship attention in the notification. It is specifically said any decision, any matter to be considered, the government decision has to be given. The director cannot give the decision. On this notification, whereby the one-time terminal benefit has been provided to the petitioners. Any confusion arises, the matter has to be finalized by the government, not by the director.
So, Mr.
And
Shakir, should we refer the matter?
Yes.
Should we refer the matter to the government?
Yes, Lordship
To decide.
disposes with a my lord, Lordship disposes of the short order. My lord, mentioning this notification also, my lord, sent to the government will consider. Okay.
All right.
He
Where-
say, no problem at all.
We'll dispose it of that.
Yes.
This is after the lawsuits, my lord.
Where is that notification?
Notification page 102, my lord.
102.
102. Where is the original copy?
My lord.
Where is the original copy? This is a type copy.
Type copy.
You have not annexed the original copy.
No, in Assamese.
No, it's there. It's 105. Is this the one? $105 is the original copy, I think.
105, yes. Yes, madam, yes. Yes.
Yes. Your good name is Mr. Mother Bhuya.
My lord, Rajguru Bhuyan.
105.
Rajbar Bhuya. Heard Mr. M.H. Rajbar Bhuya, learned counsel for the petitioners. And Mr. D.C. Sudhia, learned additional senior government advocate for the state respondents. Stop having regard to the nature of the controversy projected in the instant case. The writ petition is taken up for disposal at this stage with the consent of the parties. So it is the case of the petitioners that they were engaged as either Anganwadi workers or Anganwadi helpers under the Child Development Project Officer, Dhauka Khana, Lakhimpur District. In the years 1975, from 1976, 1977, etc. And after rendering service for about 40 to 45 years, continuously, they were released in the year 2015. And 2016. Without any terminal benefit. Stop. It is the case of the petitioners that the state government in the Social Welfare Department has come up with a notification dated 1/4/2022. Bracket annexure. Two. Close bracket. By which terminal benefits have been accorded to the Anganwadi workers and helpers. Stop. According to the petitioners, from our similarly situated persons had been given the terminal benefits, but in respect of the petitioners, as it was not given, they have come before this court seeking a direction to the respondent authorities to give them similar benefits. So Mr. DC Chutia, learned State Council, submits that the notification dated 1/4/2022 is in the form of a scheme and has come into force with effect from 1/4/2022. And therefore, the petitioners who have since been released from service
Two 2012, 2014, 2016, 17.
way back in the years 2000,
141.
2000,
141 page, my lord. Their termination of death.
since 2012
2014.
and thereafter will not be covered by the said scheme. And that the instant writ petition having no merit should be dismissed. Mr. M.H. Raj Barbhia, learned counsel for the petitioners, on the other hand, by referring to the notification dated 1/4/2022, submits that if any question arises with regard to the interpretation of the provisions provided by the said notification, the decision of the state government would be final. Full stop. Therefore, the director cannot take a decision with regard to the entitlement of the petitioners. As was done by his communication dated 1/2/2025. under memo number DWCD bracket LC close bracket 17/2024/274, which was addressed to the Child Development Project Officer, Dauka Khana, ICDS Project, Lakhimpur. So he therefore submits that it is for the state government to take a decision in the matter with regard to the interpretation of the notification dated 1/4/2022. Next, whereas having regard to the above projection and without expressing anything on merit, the writ petition is disposed of by directing the respondents, more particularly the respondent number
Commissioner Secretary.
You come to page 11, we have the principal secretary.
Yes. Principal Secretary of Dr. Social Development.
Respondent number 1, that is the principal secretary to the Government of Assam, Social Welfare Department, to take a decision.
Now it is bifurcated matter instead of Social Welfare Department, Child and Women Development.
What about secretary? There'll be only one?
No, matter social justice is there. Two defines. That's why I
So
cannot say.
that is why I was asking you what to do.
Yes. Principal, what's it? Social. Principal Secretary.
Who shall take, just read that sentence with this post with direction to the to take from there you cut. The Department of Respondent number 1, to the Principal Secretary of the Government of Assam, Social Welfare Department. To take a decision in a matter as regards the applicability of the notification dated 1/4/2022 to the case of the petitioner. Petitioners.
Yes. The petitioner will submit the certified copy of this order along with all these document, all additional affidavit and retribution to the respondent number 1.
Writ petition will do, I think, not the remaining counter affidavits. This is your document. Such decision, the respondent number 1 shall take the decision as directed herein above. Within a period of 6 weeks from the date of receipt of a certified copy of this order.
Along with
The petitioner
Petition or all other annexures.
and additional affidavit. He will submit along with the order,
The certified copy of the lawsuit ordered along with the copy of the writ petition and the annexures acting in between the parties. The CDP has given an annexure. I have submitted my additional affidavit. All these
the
matters.
petitioner shall also submit a copy of the writ petition along with all the annexures
An additional affidavit.
and the additional affidavit to the respondent number 1.
In the period of 1 week, my lord.
Along with the certified copy of this order. Time is not required.
A time limit may kindly be given, my lord.
6 weeks.
I said 6 weeks.
6
6 weeks. If you submit tomorrow, you'll get 6 weeks after that. If you submit next year, then it will be 6 weeks from next year. It's up to you.
After submission,
Obvious,
within 6 weeks after submission, I will submit it within a
Yes,
shortest
yes,
possible
I've
time.
already said that. Yes.
Obvious.
Privilege, your lordship. My lord, petitioner was as LDA in the higher secondary school, that is government GMSH school, phase 55 my lord. There was a dispute regarding the amount of pension he is entitled for. There are a large number of communications in this regard. Kindly see now page 54 by. In 54, the senior accounts officer of the AG office.
Mr. Mahmood,
Correct.
see, affidavit has not been filed, I think.
They have not yet filed.
Who is appearing? Who are the respondents?
But my lord, my position is this, my lord. I am now only getting lump sum pension of 15,000.
Maybe, see, it
that-
is only one side of the story now. Unless they file something, what to do?
But if they do not file, lordship may.
Now, so we'll have to give them time.
Last time then maybe.
Last time what happened was, I think notice was complete, I think. Who is appearing for the respondents? Secondary education. You are Accountant General. Any instruction? No, what is that? You file affidavit if you have the instruction.
Well, it is a very simple case because I have drawn a sum rupees 51,000 at the time of my retirement. So I am easily entitled 51,410. So half of the amount would be the pension. But they are not paying only rupees 15,000. And that too by court's order. So a person who has served his entire life for the state, now he has been deprived from proper pension. And pension matter, he cannot run away his family by this bigger amount. So my lord, a short date may be fixed on that day, matter may be disposed of. They may file affidavit or may not. Because everything is based on papers. Man.
This is regarding what deduction?
Deduction was there. Deduction means, my lord, first I was appointed as laboratory assistant. Then I was promoted as LDA. Then I filed writ petition in High Court, I was promoted to UDA. Then again, suddenly I was reverted back to LDA. But I was working as UDA. I was always working as UDA, which is certified by the principal also. So accordingly, I got some rupees 51,410 rupees per month. And accordingly, my pension was fixed. But that pension is not paid due to accounts officer's intervention. So my submission is this, my lord. This 15,000, I have marriageable daughters also.
Please write down Mr. M.U. Mahmood, learned counsel appears for the petitioner. While Miss, your name? R.K. Talukdar. Learned counsel appears on behalf of? Respondent number 3. No one appears for the remaining respondents. Considering the stand taken by the petitioner, an affidavit in opposition would be required from the respondent authorities concerned. So, in view of above, matter stands adjourned for 3 weeks to enable the respondents to file the counter affidavit. List the matter again on.
That will be fixed.
This is the matter again on so and so. Give a date, please. 16 June.
16/6. All right.
May I please, Your Lordship? My lord, we have preferred two interlocutory applications for impleasment of new parties, the PNRD department. So, Your Lordship, there was a confusion as to the cause title, because what we have done, the original respondents of the writ petition, we have made them parties in the interlocutory application. So, in the order dated 19/3/2025, Lordship may kindly take that order passed by this court.
In the IA or the WPC?
I think it is in the WPC itself,
Order dated?
19/3/2025.
But there's no such order.
Then the Lordship, it will be in the IA number 744.
19/3.
19/3.
That also is not there.
Then Your Lordship, the another IA is IA 743. Maybe in that, it is in that.
Not even this one. Oh, just a minute. Yes, 19/3. Yes.
19/3.
IA 743.
743, yes, Your Lordship.
What was this IA for?
IA is for impleasement of PNRD department,
PNRD.
PNRD.
Then
So what we have done is that we have made the original respondents of the writ petition as party in this IA. So the query was raised was why to make them party? Only make the two parties whom you want newly implead, only make them party as party number 1 and 2. So a report was sought from the Registrar Judicial. That report has come, Your Lordship.
by which order?
This 19/3/2025 called for a report.
Okay, just read the 19/3.
Yes. Lordship, may I read it from the beginning?
Yes.
Heard Mr. F. Khan, learned counsel for the applicant. Lordship, can I?
By
skip it?
filing, third para, by filing.
By filing this interlocutory application, the applicant is seeking impleasment of two officials as respondent numbers 14 and 15 in the connected writ petition. However, those two authorities have already been shown as opposite party numbers 14 and 15 in the present interlocutory application even before the prayer for impleasement has been allowed by the court. Since the present case management system in the High Court is mounted on the central CIS system, wherein electronic database is being maintained in a central server, it has become necessary for this court to ascertain as to whether the opposite party numbers 14 and 15 ought to have been implemented only as opposite party numbers 1 and 2 in the interlocutory application, and only after the court allows the player of impleadment can they be implemented as respondent numbers 14 and 15, or whether these two opposite parties can directly be shown as opposite party numbers 14 and 15, regardless of whether the impleadment prayer is allowed or rejected by the court. Next page, Your Lordship. In order to have clarity in the matter and to avoid further complications in the matter insofar as the CIS system is concerned, this court is of the view that the report from the registry ought to be called for throwing light on the issue. As such, the Registrar Judicial to examine the matter and submit a report.
Yes, where's the report?
The report is, it is there, Your Lordship. Report dated 26/3/2025.
Where?
It will be in the record, Your Lordship.
Report dated?
26/3/2025 by the Administrative Officer Judicial Filing Section. It is flag marked, Your Lordship.
Yes.
Yes. May I read it, Your Lordship?
Yes.
This is with reference to the Honorable Court's order dated 19/3/2025 in IS Civil 743 of 2025. In response to the concerns raised by the Honorable Court regarding the impleadment of parties, it is respectfully submitted that there is no single uniform practice followed in this regard. In some instances, the Learned Counsel specifies only the parties to be newly impleaded as respondents. In other cases, the counsels maintain continuity with the existing parties to the main case, while some counsels mention the parties to be impleaded solely in the body of the interlocutory application as well as in the prayer portion. However,
it may be noted that the impleadment of new parties is carried out in the main case only after receiving approval from the Honorable Court. The necessary amendments to the cause title of the main case are made in the concerned sections as and when the Honorable Court allows the prayer for impleadment of the new parties. So, Your Lordship, irrespective of how the parties are made, it is only after the court passes an order, they will be impleaded. So, Lordship, at this moment, I pray that the interlocutory applications may be disposed of, it may be allowed. And
This one's still pending.
pending, Your Lordship.
IA 743.
743 and 744, both are pending.
What is 744?
744 is to implead opposite party numbers 14 and 15 in the original writ petition.
Then
And
743?
743 in this original writ petition, there is a connected IA, which is IA number 3307. There is another IA number 3307. So 743 is to implead them in that IA. So
743 is for the IA
743
and
is
744 is in the writ petition.
for a writ petition.
And that IA is for what?
IA 3307 is to keep the post vacant in which I am claiming appointment. IA 3307. So today your Lordship 744 and 743 may be disposed of.
Please write in IA 743 of 2025. Part Mr.
A Khan.
A. Khan, learned counsel for the applicant, who submits that by filing this application, the applicant seeks impleadment of
Principal Secretary, PNRD Department.
where is it shown?
Might be find it in the prayer portion. Page number.
Just a minute.
Yes.
Principal Secretary, Panchayat and Rural Development Department, Guwahati, and the Commissioner, Panchayat and Rural Development Department, Guwahati, as party respondent numbers 14 and 15. In
IA number 3307 of 2024.
In IA 3307 of 2024.
That is for 743.
Now, the learned counsel has also drawn the attention of this court to the order dated 19/3/2025 passed by this court and the clarificatory note made by the Registrar Judicial on, this is 25 or 26? Clarificatory note?
It is overwritten, Your Lordship.
So which one should be the right?
I prefer it is 76, maybe.
Clarificatory note dated 25/26 March 2025. Now, as per the clarificatory note, it has been indicated that impleadment of parties are made only after permission is given by the court. Stop. Therefore, it appears that there is no impediment in impleading the respondent numbers. Impleading the Principal Secretary, Panchayat and Rural Development Department and the Commissioner, Panchayat Rural Development Department as respondent numbers 14 and 15 in IA C number 3307 of 2024. Stop. Accordingly, the interlocutory application is disposed of as allowed and as prayed for. Then in IAC number 3307 of 2024, you write like this. In view of the order passed today, in IAC number 743 of 2025, the two names, okay? The Principal Secretary, Panchayat and Rural Department, and the Commissioner, Panchayat and Rural Development, are hereby allowed to be impleaded as respondent numbers 14 and 15. Applicants to submit the amended course title in 2 sets before the registry of this court within
2 days. 2 days.
Within 2 days. When to be listed then? List the matter again after?
Maybe a week,
No.
as per your lordship's convenience.
Okay, list the matter again after a week.
If a
So-
date could be fixed, your lordship.
Okay, then list the matter again. On 2nd of June.
2nd of June,
Oh.
lordship.
So that takes care of the thing. And what is the other IA?
IA number 744 of 25.
Okay,
To include
this
the
is
same in
the writ petition. IA number 744, okay, of 2024. Part Mr. So-and-so, learned counsel for the applicant who submits that by filing this application, the applicant seeks impleadment of that two persons, Commissioner, impleadment of the Principal Secretary, Panchayat, and Commissioner Panchayat as respondent numbers 14, 15 in the main writ petition, that is WPC number 2869 of 2024. Stop. He submits that impleadment of these 8 parties is necessary for effective adjudication of the matter. Mr. B. Chaudhary, learned,
Lordship, I'm appearing for state level recruitment commission.
appearing for which respondent?
Number 3. Respondent.
For 1 and 2.
And Miss S. Barua appearing for respondent number 1 and 4.
1 and 2.
1 and 2. Has no objection to the prayer. In view of above, the application for impleadment of the above parties as respondent number so and so is hereby allowed. IA stands disposed of. Then in the main writ petition, you write, in view of the order passed today in IAC number 744 of 2025. The Principal Secretary, PNRD, and Commissioner PNRD are hereby permitted to be impleaded as respondent numbers 14 and 15. Stop. Petitioner to furnish, petitioner to submit, petitioner to file the amended cost title before the registry within 2 working days. Anyone to accept notice? PNRD?
Lordship, PNRD is pending counsel is there. He has to serve copy upon them, Lordship.
No, he'll serve now.
Of the original writ petition.
Yes.
We'll do it. In 2 days' time, we'll do it. Today.
Next para.
Today also we can do it, your lordship.
Yes.
Yes, sir.
Issue notice to the newly impleaded respondent numbers 14 and 15. I think we'll have to take it to the date will have to go a bit farther away.
My lord.
Returnable by 3 weeks. Who's the standing counsel? PNRD? Mr. K. Kuar Lanet, standing counsel, PNRD, accepts notice on behalf of this newly impleaded respondents numbers 14 and 15. Petitioner to serve requisite copies of the writ petition to the Lanet standing counsel within 2 days. Returnable for the same. List the matter again on 23rd of June 2025. The other case also will come on 23rd.
My lord. My lord.
The earlier case, no? Make it 23rd. The newly impleaded respondents will be at liberty to file their counter affidavit in the meantime.
My lord.
All right.
Oblige, man.
Item 26.
May I please, your lordship?
Yes.
My lord, the matter relates to, my lord, holding the charge of the headmaster of a, my lord, secondary level school, my lord.
Lord, our challenge is that I am the eligible and qualified and senior most person in the school. But my lord, the charge had been conferred to a person, my lord, who is not qualified to hold the post, my lord, who the B.Ed degree is not there. My lord, the till date, no affidavit, nothing has I have received, my lord, long back notice had been issued. So my lord, my case is very limited. If that person is not qualified, my lord, he cannot hold, or if he has the qualification, then the case will be not otherwise. Now, my lord, what has happened, we have challenged and speaking order, my lord.
Respondent number 4, man.
Who's respondent?
My lord, is,
Private respondent.
my,
He is
What
holding-
about the official respondent? You're the one who's holding the charge.
Yes, yes.
my lord.
Mr. Sutia, you are there in this case?
No, no.
Secondary education?
Which department? Secondary education, I am not.
Anybody,
No, no.
any standing counsel?
My lord,
Yes,
they have, my lord.
secondary.
Coming, my lord, they informed,
What is this page 51?
my lord. My lord, the
51 is
order,
impugned.
impugn is at page 51, annexure 14. my lord.
51 is impugned.
My lord.
Order to the,
9/8/2023, my lord.
the one order they have not annexed with this writ petition, my lord. Can we see the challenge the order?
So,
That-
see, if that dispute is that the private respondent is not qualified
My lord.
to hold the charge, let somebody look into it, let the director look into it and take a decision then.
My lord.
All right?
My lord,
Can we see
direct-
the-
My lord,
see the
director,
page 51, my lord.
Yes.
My lord, the director order, my lord. After submit-
Director has given the order.
Yes,
So it should be the secretary then.
my lord.
my lord.
Secretary.
My lord,
Secretary will examine who is qualified, whether you are qualified or not.
Yes, my lord.
If you are qualified, then you will continue. If you're not qualified, then he'll decide.
my lord, can we
Because there's no affidavit coming
see
till
the
now.
order, my lord. He denied to take the charge, my lord, first time. He, no doubt, he is a senior assistant teacher of the school, my lord. I am the second one. After denial, my lord, director giving me the charge, my lord.
Yes, Mr. Bhuya, why you have to deny it?
No, my lord, initially some personal difficulties were there, my lord. That's why at that relevant period of time, sometime, my lord, when we approached, my lord, before this honorable court for certain reasons, my lord, what has happened, my lord, this issue has already been adjudicated in the first round of
But
litigation.
what is that difficulty? Tell me.
No difficulty, my lord, one of my, my lord, son and some other family affairs was there. That's why, my lord, at that relevant period of time, I could not hold. But, my lord, even if I assume, my lord, I am not holding, but can a underqualified person be allowed to, my lord, manage the affairs? It will be. my
That's a
lord,
different thing.
No, my lord, it will be a disastrous for the school also. Now, my lord, that issue has already been
At one
adjudicated.
point of time, you were offered, you refused, and
No,
now you
no.
want to come back
That,
again.
that has been
That
taken
is
care
the-
of, that has been taken care of by this honorable court, my lord, in an order, my lord. But that I have, my lord, my lord, there is an order of this honorable court at page 45, my lord.
Regarding what?
Yes, my lord, regarding that, regarding refusal of holding the charge at that relevant period of time, my lord may be pleased to find the order starts at page 45, my lord.
This is filed by you.
Yes, my lord, this was filed by me.
First
After,
round.
yeah, first order, my lord, page 46.
What was the challenge there?
Challenge regarding this, my lord, the holding of the charge by the private respondent number 4, my lord. At that relevant period of time also, the issue has been directed to be examined by the director, my lord. And the director has come up with this impugned speaking order, which is now under challenge in this petition, my lord.
51.
So that issue cannot be again reopened, my lord, by my learned respected senior friend, my lord.
No, see, what was challenged in that case?
My
Tell
lord,
me.
the challenge, if I may be allowed to read over the order, my lord. The petitioner stated that the respondent number 5, an assistant teacher who is presently holding the post of headmaster in charge, through the received graduate scale of pay of so and so, but he does not have the B.Ed degree. As such, the said respondent number 5 does not have the eligibility to be a headmaster in a provincial secondary school. By placing the seniority position of the teaching and non-teaching staff of so and so, its amalgamation of the that it was forwarded by the inspector of school, Nagaon district circle, the Director of Secondary Education Assam on 1/11/2022, the petitioner stated that the said respondent number 5 is junior to him as the said respondent received the graduate scale of pay 2 years later than him. It is contended by the petitioner that since the respondent number 5 does not have the B.Ed degree, he does not possess the eligibility to be a headmaster of any provincialized secondary schools of the state as provided under the provision of Assam Secondary Education Provincialized School Service Rule 2018. In that regard, Mr. So-and-so, learned counsel for the petitioner, placed before the court the relevant judgment passed in the case of so-and-so, so-and-so of so-and-so. Relying on the provision of Rule 24(5) of the so-and-so, the petitioner submit that he is senior to the respondent number 5 and has all the requisite eligibility to be headmaster in the said so-and-so, so-and-so school. After hearing the learned counsel for the parties and considering the entire aspect of the matter, the petitioner is directed to submit a first representation before the Director of Secondary Education Assam on or before, along with a certified copy of this order and a copy of the writ petition, including the annexure appended thereto stating his grievances. In the event of filing such representation by the petitioner with the time so specified, after giving an opportunity of hearing to the petitioner as well as the respondent number 5 and considering the relevant records of so-and-so, so-and-so Nagaon, the Director of Secondary Education Assam shall dispose of the said representation or the petitioner with a speaking order intimating him about the outcome of the same. With the above observation and direction, the writ petition stands disposed of. Now, my lord, considering this impugned speaking order had been passed, my lord. The relevant case law which has been discussed in the first round of litigation, my lord, has been ignored in the speaking order also.
When were you offered the post of in charge headmaster?
My lord, I have not been offered. The private respondent had been offered, my lord, by an
No.
order, my lord, which has not been furnished to me, my lord.
No, this order of 9/8/23 says that
My lord.
Sri so-and-so submitted a prayer petition showing his unwillingness to hold the charge of
That is
headmaster.
myself, my lord, myself.
Correct.
That initially, my lord, I intend that I have, my lord, submitted before my lordship, my lord.
When did you submit
My
your
lord, I
unwillingness?
submitted immediately after the retirement of the regular headmaster in this school, my lord. At that relevant period of time.
So that's why the instant respondent number 5 was
No, that is
put-
correct, my lord, but
put
that
as in
was-
charge
that-
principal.
That was for a temporary
No,
period.
just listen. When the regular headmaster retired,
My lord,
you gave one application that you're not willing.
my lord,
And the respondent authority has appointed or given the respondent number 5 the charge of the
that is
headmaster.
correct, my lord,
Then you file the writ petition,
my lord.
After
And-
1288.
Yes, my lord, and that writ petition, this order had been passed and it has not been.
1288, you have filed that writ petition on the ground that the respondent number 5 does not qualify.
Exactly, my lord,
So now they passed, after that, the writ petition was disposed of,
my lord,
saying that you may file representation.
exactly, my lord.
And your representation has been disposed of.
Disposed by
And-
rejecting my claim, my lord.
This order 9/8/23 has been passed.
Exactly, my lord.
Hmm. So what can be done now? If you don't qualify, you don't have B.Ed. I know.
In charge headmaster,
In charge
My
also
lord.
requires qualification.
my lord, since 2018, my lord,
Mm.
my appointment order was on 9, my lord. He mentioned the appointment order 10/10/2018. He did not submit any order, my lord, along with this writ petition, my lord. My joining and my order was 9/10/18, my lord.
All right, then to
After
file.
9/10/18, my lord, he came before your lordship in 2022.
Okay, you file your affidavit then.
Yes, my lord.
You have not filed.
Yes, I will file.
When will you file?
10 days time.
State. Mr. Khatanya, you'll file
We'll file, madam.
on the prayer made by the learned counsels for the respondents, including the private respondents. Further 2 weeks time is granted to file counter affidavit. List the matter again on so and so. On 9 June.
9 June.
Madam.
Yes.
Well,
Well.
obliged. madam.
May please your lordship.
Yes.
By this petition, I have challenged the order of giving me premature retirement, lordship. In this case, notice of motion was issued on 27/6/2024, lordship. No affidavit has been filed till date, lordship.
Who are the respondents here?
Lordship, they are the PWD department, lordship.
Premature retirement.
Yes, lordship. Actually, I have to go, my date of retirement on 34/20/2031, lordship, but I was given retirement on 34/2024, lordship.
Why is that?
Lordship, notice is lordship page 29, lordship.
Something to do with your date of birth?
Yes, my date of birth is lordship date 2/4/1971, lordship. Which is reflected in the service book also, lordship.
And instead they have accepted some other date of birth.
Yes, lordship. Instead of that, they have given me retirement 7 years before, lordship. So notice of motion was issued almost 1 year back, lordship, but till date no affidavit has been filed.
PWD, anyone? They have the standing counsel,
Yes.
PWD. Please write hard Mrs. P. Bhattacharya, learned counsel for the petitioner, who submits that the petitioner has been prematurely retired on 30/4/2024. Although he was supposed to superannuate on 30, I mean, he is to superannuate on 2031. Stop. Having regard to the projection of the petitioner, the respondents would be required to file their counter affidavit. Stop. In view of above, further 3 weeks time is granted to the respondents to file their counter affidavit.
Lordship, can I fix a date after?
Yes, list the matter again also and so. You may also inform the PWD also that 3 weeks time has been granted. Huh?
This
This is the matter again on 16th June.
Wait, wait, wait. In this case, notice was issued on 19/8/2024. But the respondent has not filed any affidavit till now. So they will be directed to file the affidavit.
Similar matter has already discussed by this honorable court on delay and noxious ground, lordship.
What is the similar matter?
So this matter pertains to recruitment by the Staff Selection Commission for constable in the armed forces. 2018 advertisement, 2021 is the result. This case was filed in the year 2024.
After that, 3 recruitment process has been completed, lordship.
Delay in latches.
Yes, Lordship, 2018 advertisement has issued, was received. And select list was published on 2021. After that, pre-recruitment process has already completed, Lordship.
Which recruitment process you're challenging?
It is 2018, Lordship. Result was in the year 2021. Lordship, what happens, Lordship? I have explained in para 34 the ground of delay. Lordship, I once see at page 23. What happens, Lordship? This honorable court allows those petitions which were filed till that time, but this petition was left. This case was left out, so this matter would not be disposed of.
Vacancy not there, Lordship, and after that pre-recruitment has process has also completed.
Lordship, let them, my learned
Now
directed
recent-
to file the affidavit, Lordship.
Not
I will
required, not required. I think this is hit by delay in latches.
Lordship, may I kindly see para 34.
I've seen it. We'll dismiss it.
Because his brother expired due to some illness and he could not come to the court within time.
No, see, process. She says that 3 recruitment process has happened thereafter. How can you get a relief now at this stage?
Regarding that delay, Lordship, if other person is not affected, then in the writ petition, that delay may not be a bar of allowing the petition, Lordship. And if I am allowed, then nobody shall be affected because vacancies will be
Not
every year.
vacancy, not there.
In every advertisement, there will be more than 50,000 vacancies. So by now, there
No,
will be some
and
vacancies.
last recruitment process, there is no vacancy there.
It may arise in the meantime. Vacancies may arise in the meantime also.
No, but the
Because
delay.
these persons were, he scored more marks, but he was not selected. This illegality is done by the respondent. Only because of delay now, if nobody will be affected by allowing this petition, then person may give me some time, I can show the authority also, some authority also regarding this delay.
This court is also aware.
Yes.
When third party right is not affected, then there's no, delay is not a
Yes, and every year
detrimental.
vacancies are rising.
But the thing is that this is a selection process of 2018.
Yes, sir.
Much water has flown thereafter. 1, 2, 3 selection process is gone. Now, if the floodgate is open, tomorrow another 10% will come. Saying that, see, in his case, reconsideration was done. We are also affected. We should be reconsidered. There'll be no end. So that premise, we cannot entertain your petition.
This case was filed in the year 2024 in the month of August.
Yes, maybe.
So, Lordship,
Maybe, but the advertisement was of the year 2018 July.
Lordship, by
So-
that time, all petitions were allowed. All petitions filed till that time was allowed by this honorable court.
Filed by which time?
By the month of August 2024, those petitions were
Was
filed.
allowed.
Yes, those were
Show me
allowed.
where's the order.
I can show you, Lordship. Lordship, give me some time.
Allowed means disposed of.
The persons were given, directed to given.
Okay, show us, show then.
So, Lord, because that order, it says 88, Lordship will find.
88.
Yes. This was the order of 19/7/2024.
This writ petition was filed on 23, Lordship. Vicky Rabha and another.
Other
On that time,
No, other order is not available with me.
instructions required by the honorable court and hearing also completed. After that, this order was passed on 24, but the petition was filed on 23. And the results were declared on 21 and petitions filed on 23. Therefore, delay and latches ground was not applicable that time. But after that, all writ petitions are dismissed by this court Several orders are there, Lordship.
What is the nature of your grievance? You were,
Uh,
you were rejected at which stage?
At the final result,
Uh,
some general candidates who scored lesser marks than me,
uh,
and I did not avail any relaxation of a OBC candidate,
Hmm.
but I was not considered. If since the rule is
You,
that-
you participated from the general category.
I participated as a OBC candidate, but I did not avail any relaxation. Therefore, I may be considered as a general candidate.
No, if you participated as an OBC, are you again supposed to
No, I did
separately?
not take any relaxation.
No, separately, you have to avail for relaxation.
Yes, Lordship, I did not take any such relaxation. Although I applied.
No, the moment you say you're OBC, then you're not given the relaxation clause.
Lordship, may kindly see the advertisement first.
You get my point? You are saying you are OBC. So the moment you have opted as an OBC candidate, so whatever relaxation is available to an OBC candidate, is it not given straight away?
No, Lordship.
You still have to opt.
In the advertisement itself, there is a clause. I may be allowed to show that.
Anyway, you consider this aspect, we'll adjourn it today.
I shall come prepared with that.
The petitioner has challenged the rejection of his candidature in the recruitment for Constable GD in Central Armed Police Force, NIA and SSF.
May I interrupt for a moment, Lordship? That clause is available at page 49.
Yes.
Page 49, it's serial number 13, Roman 13. ST, SC, OBC, and ex-services candidates who are selected on their own merit without relaxed standards, along with candidates belonging to other communities, will not be adjusted against the reserved share of vacancies. Such candidates will be accommodated against the unreserved vacancies as per their position in the overall merit list. The reserved vacancies will be filled up separately from among the eligible SC, ST, OBC, and ex-service candidates. Also, I did not avail any relaxation. There are cases, judgment of this honorable court also in this similar matter, that if I did not avail any relaxation, then I may be considered as a general candidate, unreserved candidate. And if I am considered as an unreserved candidate, then I score more marks than the last general unreserved candidate. Also, you will find that mark at page 86.
Madam, you file your affidavit. Oh, I don't think we can take that up like that. You file affidavit?
No, we have not filed affidavit.
You will file your affidavit. We'll give you time. You explain all the delay also, whatever. Take the stand.
In this regard, I have to take instruction, Lordship. Similar matters are already dismissed by this court. That's why instruction not received, Lordship, till date. I have to take instruction to file affidavit, but vacancy not available, Lordship, and
So whatever stand you're going to take, you file an affidavit. We'll see. As paid for by the learned CGC, further 3 weeks time is granted to file counter affidavit. The stand that the writ petition is barred by delay in latches is left open to be considered. Correct.
Well, in item number 30, I'm not pressing this petition, my lord, since the petitioner has already been appointed. my lord.
You are Mr. R. Islam.
Yes.
Mr. R. Islam, learned counsel for the petitioner, submits that since the petitioner has already secured appointment, he is not pressing the writ petition.
My lord, in item number 31,
Just a minute, in view of above, WPC number 4778 of 2024 stands dismissed as not pressed. Registry to detach the same from WPC number 34382 of 2024. Okay, in item number
in item number
31?
31, my lord, I may be allowed some time to file the 31, rejoinder. my lord. we have filed affidavit, my lord. We have clearer state, my lord. And the matter is very simple. The petitioner. I will file the reply, my lord.
He wants to file rejoinder.
Yes.
Let him file. As paid for by Mr. R. Islam, learned counsel for the petitioner. In WPC number 4382 of 2024. How much time?
2 weeks time.
2 weeks time is granted to file a rejoinder affidavit to the affidavit in opposition filed by the state respondents.
Much obliged.
Well, in item 32 and 33, my lord, I have received the instruction, my lord. So I need some time to file my proposal.
How much time?
2 weeks, my lord.
As paid, Mr. N.J. Katania, learned counsel appearing for the secondary education department, submits that he has received the instructions and prays for 2 weeks time to file counter affidavit. Praise the Lord.
Date may be closed. Date may be closed.
List the matter. In the second week of June. On 9th June.
Obliged.
9.
No, not as.
Yes.
Well, this is a suspension matter and petitioner has been placed under suspension. And my case was, the contention was that no review was done. After filing this petition lawsuit, some order has been lost. May I pray lawsuit, they have filed their affidavit. My lord, matter is required to be disposed to lawsuit. May I pray this matter may be taken up on the hearing day of Thursday lawsuit.
We have filed affidavit, my lord.
Yes, affidavit.
In our affidavit, my lord, we have stated, my lord, we have periodically extended his suspension order and departmental proceeding is drawn and is going on.
That part will be taken care of once that.
Fixed for hearing that, my lord.
On the Thursday lawsuit, advisory hearing.
Next Thursday.
Next Thursday, 29.
Okay. Parties are represented by the respective councils and they submit the pleadings are complete. Stop as paid for list the matter on 29th
29.
of May 2025 for admission hearing.
Again, 26.
So in this case, no affidavit has been filed by the respondent lordship.
Lordship, we have received the instruction. Lordship, we are allowed 2 weeks time, we will file affidavit.
Mr.
P.N. Sharma.
P.N. Sharma, learned state council, submits that.
Standing Council, Elementary Education Department.
Learned standing council, elementary education department, submits that he has received the instructions and prays that he may be given 2 weeks time to file the counter affidavit. Praise the Lord.
Kindly fix a date also.
List the matter again on so and so.
After 2 weeks. 11 June.
On 11 June.
Lordship, here in this case, we have received instruction, Lordships, and I may allow 3 weeks time to place this on record, Lordship.
3 weeks will be a bit long, your lordship. May I pray that at least a week's time, your lordship, and a date will be.
Miss M. Bhattacharjee, learned additional senior government advocate, submits that she has received the instructions and therefore she may be granted 3 weeks time to file the counter affidavit. To stop. The learned counsel for the petitioner, Mr. T. Diori, on the otherwise submits that a shorter date may be given since there's urgency in the matter. Considering the submission made by the parties, let the matter be listed on 11th of June, 2025.
Very
Affidavit
grateful,
to
Your
file, June.
Deeply obliged, Lord.
Yes.
May I please, Your Lordship? Matter relates to transfer of the petitioner, Lordship. Already, Lordship. On two grounds, I have challenged the order, Lordship, basically. One is, Lordship, the.
Matter is ready for disposal.
Yes, my lord. But already interim order is there, Lordship. I have already got the stay order, Lordship. And I have filed, the learned pen also filed affidavit in opposition. I have also filed a reply,
Okay.
Lordship.
That's good. So we'll take it up for consideration when?
Next Tuesday, my lord.
We are short of time today, in
Yes,
fact, so.
Next Tuesday, my lord.
Parties are represented by the respective counsels and they submit that the pleadings are complete and the matter be taken up for admission hearing on
27th.
27th of May, 2025.
Most obliged.
In view of above, list the matter on 27th of May.
Interim order passed earlier shall be continued.
Interim order passed away shall continue till the next date.
Yes.
This case, my lord, no affidavit has been filed by the
Some time we
respondent.
granted to file.
How much?
My lord, 4 weeks time, lord. That may be fixed, my lord, but
Mr. S. K. Mehdi, praise for and is granted. Mr. S. K. Mehdi, learned CGC.
no, my lord, for standing only account AG, my
I'm
lord.
sorry, learned CGC.
Not AG.
Learned Standing Council AG Assam, praise for and is granted for the 4 weeks time to file counter affidavit. List the matter again also and so. Give the date, please.
When? 25.
Obliged.
61.
My picture also. This is a family pension matter, my lord. I pray early date may be fixed, my lord. And if you.
Pleadings are complete or
Affidavit file.
who is for the other side?
Counter General.
And who else are there?
The Upamanyu is there for education department. Higher education. Higher education. Any Tuesday or Thursday also.
Due to positive time, matter could not be taken up for consideration today. As paid for by the parties, list the matter. On 10th of June
Must
for
be.
admission hearing.
Must be.